This is him.
Good morning.
Hey, how you doing?
Good, how are you?
Doing well, thank you. Question for you. You're seeing 3 guys, right?
Correct.
Do you care in which order they come in the room?
If possible, I'd like to see them in order, like Shepard, Hughes, and Grant.
Like how it is on the list?
Yes.
Okay, because I called both. All right, I got you. I'm just gonna have to grab one differently. I got you.
Oh, thank you. Good morning, P.O. Montoya.
Good morning. I set up this background as a joke, and I kid you not when I tell you I don't know how to take it off, because we had a meeting here at work, and as you can see, it's like a jail cell, and I don't know how to take it off. Let me see if I can figure out how to take it off.
Would you like help? Because I can walk you through that.
Could you please?
Yes.
This was a joke, and I don't know how to shut it off now.
So if you see where the video icon is, you'll have a little arrow right next to it.
Yeah. Yeah.
If you press the arrow, go to more.
Thank you.
You're welcome.
That's not how. This is not how I wanted to conduct a hearing. Like I put that on as a joke when we were having like a staff meeting, you know, to joke with the supervisors here. But then I didn't know how to turn it off.
Well, you're
not a problem. But you found
Thank
it.
you.
And now next time.
Thank you so much for your help.
You're welcome.
Just as there's a video saying that, when you are done, he's in the audio for you.
Meisinger, we're hearing Shepard first, right?
correct.
Okay.
Right there on the TV, yeah.
Good morning, Mr. Shepard.
Morning.
Morning. So we're here today for your preliminary hearing, and we're going to get started with that, okay?
Okay.
Good morning. I am Parole Officer Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Shepard Robert, number 2666562. Today is October 8th, 2024. This hearing is being conducted via video at the BOPP Central Office in New Haven Correctional Center. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state for me your full name and DOC inmate number for the record?
Robert Shepard, 266562.
We have a parole officer present. Can you please identify yourself for the record?
Good morning, Catherine Montoya.
So this is a preliminary hearing, which the purposes under Connecticut law is to determine if there is probable cause to believe you commit an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, release you, and place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. This is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge, state your appeal is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to just issue a probable cause in the spirit of the allegations. After the state is finished, you will have the same opportunity. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, I don't.
Okay. So you have important rights today. Your right to have an attorney present. Do you want to continue without counsel?
Yes, please.
You have a right to receive the written notice to charge of the violation. Did you receive the written notice?
Yes, I did.
You have a right to view the evidence. You have a right to submit evidence in support of your case. At this hearing, right to call and examine voluntary witnesses to cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes, I do.
Okay, so we will now review the charge the state your appeal is bringing against you and the information underlying each charge. So P.O. Montoya, please read the charges.
Good morning. We have reporting. On 8/28/2024, you were directed to report to the Waterbury Parole Office on 9/3/2024. You failed to report on 9/3/2024 as instructed and all days thereafter. Several attempts to contact you were made with negative results. Your whereabouts in the community remain unknown until your arrest on 9/19/2024. Charge number 2, Program participation. You completed a phone screening with McCall Foundation on 8/14/2024. You completed your intake appointment for substance abuse on 8/27/2024. On 8/28/2024, you failed to attend your telehealth visit. On 8/29/2024, you failed to attend your appointment for medication assisted treatment. On 9/4/2024, you failed to attend your intensive outpatient programming. You failed to return to McCall Foundation despite multiple calls and directions from both your parole officer and program staff. You were negatively discharged from McCall Foundation on 9/13/2024. Charge number 3, residents. On 9/4/2024, officers from the Waterbury Parole Office performed an attempt to locate a your approved residence, yielding negative results. On 9/9/2024, these officers spoke to your approved sponsor, who reported that you moved out of your approved residence on 8/28/2024. She reported that she has not seen you since you moved out and is unaware of your whereabouts. You failed to provide this officer with verification of your new address. You moved your residence without approval from your parole officer. Obey all laws, charge 4, obedience to the law. On 9/19/2024, Windsor police were called to Stop and Shop on a report of trespassing. Windsor police found you outside the store and asked you what your name was. You reported to Windsor police that your name is Jonathan Sullivan, date of birth 4/11/1977, and refused to show your ID. Windsor police asked you multiple times what your correct name is. You continue to report that your name is Jonathan Sullivan. When Windsor police informed you that you were going to be fingerprinted in order to trespass you from entering Stop and Shop, you then provided your real name of Robert Shepard, date of birth 4/11/1977. You were subsequently arrested and charged with interference with an officer. Charge number 5, drugs. On May 30, 2024, you submitted a toxicology screening at Open Heart. You tested positive for cocaine and alcohol use. You signed a voluntary drug admission form. On 6/14/2024, you submitted a toxicology screening at Open Heart. You tested positive for cocaine use. On 6/18/2024, you submitted a toxicology screening at Open Heart. You tested positive for cocaine use. You signed a voluntary drug admission form. On 6/27/2024, you submitted a toxicology screening at Hartford Parole. You tested positive for cocaine use. You signed a voluntary drug admission form. On 8/27, you submitted a toxicology screening at McCall Foundation. You tested positive for alcohol and cocaine use. On 8/28/2024, you submitted a toxicology screening at Waterbury Parole. You tested positive for cocaine use. You signed a voluntary drug admission form. Charge number 6, no consumption of alcoholic beverages. On May 22, 2024, you signed special parole conditions, alcoholic beverage consumption. Throughout your period on parole, you are prohibited from the consumption of alcoholic beverages. You will be required to submit to random toxicology screenings to monitor compliance. On May 30, 2024, you submitted a toxicology screening at Open Heart, halfway house. You tested positive for cocaine and alcohol use. You signed a voluntary drug admission form. On 8/27/2024, you submitted a toxicology screening at McCall Foundation. You tested positive for alcohol and cocaine use. No contact with co-defendants. On May 22, 2024, you signed special parole condition contact with co-defendants. Throughout your period of parole, you're not to have contact with Teresia O'Hara, the co-defendant of your offense. On 6/14/2024, you were issued a misconduct due to your parole officer seeing a picture of you and your co-defendant, Teresa O'Hara, at your son's graduation. You admitted you had contact with your co-defendant on 6/14/2024. Mental health treatment. On May 22, 2024 and 8/16/2024, you signed special parole condition. You will participate in a mental health treatment program, including monitoring for medication compliance or with DEMA support. On 8/27/2024, you failed to complete your telehealth mental health prescriber appointment. You left McCall Foundation without completing the process for your mental health evaluation and intakes.
Thank you. And the state has filed the following exhibits that are pre-marked for identification purposes. Exhibit A, remand of custody order. B, Parole conditions dated 5/22/24 and 8/16/24. C, parole violation report. D, notice of parole violation. E, Winsett Police Report ending in 6851 dated 9/19/24. Exhibit F, misconduct report, cocaine and alcohol use dated 5/30/24. G, voluntary admission form dated 5/30/24. H, Redwood toxicology lab report positive for cocaine use dated 6/14/24. I, misconduct report, cocaine use dated 6/18/24. J, voluntary admission form dated 6/18/24. K, Redwood toxicology lab report positive for cocaine use 6/18/24. L, misconduct report, cocaine use dated 6/26/24. M, voluntary admission form dated 6/27/24. N, McCall Foundation toxicology report positive for cocaine and alcohol use dated 8/27/24. O, misconduct report, cocaine use dated 8/28/24. P, voluntary admission form dated 8/28/24. Q, mere biotoxicology results dated 8/28/24. R, misconduct report violation for additional condition contact with co-defendant 6/14/24. R, misconduct report violation. S, McCall Foundation discharge report 9/13/24. T, email change Matt Foundation clinician showing Shepard was directed to complete intakes for substance and mental health evaluation. U, revocation hearing summary 12/21/22. V, revocation hearing summary dated 6/26/23. W, revocation hearing summary dated 11/14/23. And Y is case note entry dated 8/28/24. Did you receive notice of parole violation report, and those other items I marked? Did you review them, sir?
Yes, I did.
Okay. Do you need to continue this hearing to obtain any additional evidence?
I would just like to say a few things, if that's okay.
Well, I'm not at that point yet. We will be there in a second.
Okay. Okay.
Do you need to continue this hearing for any reason?
What was that?
Do you need to continue this hearing to obtain any additional evidence?
No.
Okay. We have no witnesses today. At this time, I'm going to swear in you, Mr. Shepard, as well as P.O. Montoya, so that you can both speak today. Can you please raise your right hand for me? You solemnly swear or sincerely affirm, as the case may be, the evidence you shall give concerning this case shall be the truth, the whole truth, nothing but the truth, to help you God upon penalty of perjury?
Yes, I did.
Yes.
All right, so at this time, the state is going to have an opportunity if they'd like to testify with respect to probable cause and severity of the allegations at this time.
Thank you. So I only had Shepard, technically speaking, for a week, if that. We had a nice interaction the first day I met him. He first missed his first reporting. So I rescheduled for Wednesday. He showed up that day already, have used drugs. He showed up dirty. He admitted to me, when I went to do his home investigation, I did not feel it was the best environment for him to be there. But then again, we don't have authority to, use our common sense. So we just had to approve the address. I didn't feel it was a good place for him to go, but I still, approved it. When I talked to him and on the 28th, and he showed up at my office and he was, dirty, I inquired if he had to do with his living situation. He alluded that that was the case, that he did not know the sponsor, that he had paid her about $400 to, for her to agree to be his sponsor. I will understand that. I guess he was desperate to leave the halfway house, and that's why he did that. He barely did not know this woman, and she was on Section 8, which was my first, suspicion when I went there. I just couldn't prove it. And that they were also basically being evicted, that they had to be out of the residence in about 2 months. So I agreed to go forward with the supervision. I spoke with the supervisors. I still wanted to work with him, give him an opportunity to continue doing treatment in the community, but also acknowledging that his living situation wasn't the best. I also arranged for him to go back to a halfway house in the area so he can continue going to the same provider that he started with. And he just disappeared. The following week, he wouldn't answer any of my phone calls. And when he finally answered, he's like, "Oh, I'm all the way in Enfield." And I'm like, "Why are you in Enfield? You're supposed to be here in Waterbury." And then I never heard from him again. I did attempt to locate no one opened the door. Called the hospitals. I spoke to the sponsor a couple times, who told me that she had not seen him since the 28th, basically. I I was in the process of putting together an absconder warrant when I got the call from Windsor PD that he had been picked up. So I went and picked him up and brought him back to New Haven, CC. Mr. Shepard has what I would say very poor impulse control. The issue with him is anytime he feels cornered or things are not going his way, the first thing he does, he just takes off. Evidence being his actual controlling offense right now, he's doing like 5 years for escape because he tried to take off from a courthouse. This is his, I believe, his 4th violation on this sentence, on this period of supervision, and he is unable to complete any, what I will say, good period of supervision. He's, he can do 33 days, he can do 66 days. He did like 7 days with me. So he's just has this pattern of coming out, whether it's in a halfway house and now in the community, and just from the beginning, just starting to use drugs, not stopping. And then when the going gets tough, just taking off, because he took off from the halfway house. He was out on the run for almost 8 months. So this is like a pattern that he has. When things get bad, instead of coming back to the table and figuring out things together, he just leaves and he doesn't pick up the phone and he just disappears. He still has substantial amount of supervision in front of him. My recommendation is that he needs to do a substantial amount of time inside. I've asked for a 2-year revocation. But if he doesn't get granted the 2-year revocation, he definitely needs to go to a halfway house. He definitely needs reasoning and rehabilitation, which is a program that we have for people to learn how to do better decision making. He needs to really start working with his parole officer and understanding that even when you do wrong, even when you do drugs or when you do things that you're not supposed to do, always come back to the table, talk to us so we can find a way to keep you out in the community, or even if we have to put you at top and then come back out, it doesn't always have to end up being a parole violation. You can work with your officer. You assume things that are not true. You make things up in your head that you don't have to. This is going to be a long supervision for you, Mr. Shepard, if you continue doing this. I'm asking you to stop. Whichever parole officer you end up with, just stop. If you messed up, absolutely. Just come back and talk to us, because then if you're not present, if you're not picking up the phone, if you're not coming to see us, there's no way we can create a plan to help you. And at the end of the day, that's what we're here to do. We're trying to help you. But
I'm not used to someone trying to help me. I apologize.
Your record in the community is atrocious. And I just want you to take this as a learning opportunity for you to stop. That's all I have to say.
All right. Thank you. I appreciate your comments. So at this time, it is now your opportunity to respond to parole violation charged against you. However, remember that you may remain silent if you choose. Would you like to respond to the charge at this time, Mr. Shepard?
Yes, please.
Go ahead.
I'd like to start from the beginning when I got out in May. First of all, I do have an addiction that I've been dealing with for a long time. I'm not in denial about that. And when I got the dirty urines, I actually went to the App Foundation from Hartford in June or July. And I did very well there. I completed it. And that's when I went to Miss Montoya, to Waterbury. Now, I did know the people I was going to. I just didn't know them as well as I thought I did. And I didn't know they were in Section 8. I didn't know they were selling drugs out of the apartment. And when I got there, it was like over for me as soon as I got there, because I'm an addict, obviously, and I started using as soon as I got there. And that's one of the reasons why I took off and left there without permission, because I didn't want to be around it at first. Then I was getting high, obviously. It was too late for me. But I don't deny that I have serious independent problems. Like, it's different. I'm learning new strategies and working with a clinician right now that took me on pro bono to help me develop my environmental stability. And because it's always the environment I'm in. I mean, I do very well in programs. Jail is not the answer for me, obviously. I've done this 4 times. it's my environment that I'm in, and you're right, Miss Montoya. I should have came to you for help, and I'm not used to people reaching out to actually help besides put me in jail. That's why I run. But you're right. I should have came for help. And like I said, I'm working with a clinician out of Cheshire with my addiction, with environmental stability and codependence issues. And I'm not running the streets committing crimes. I mean, the case at Stop and Shop, yes, I gave him the false name because I didn't want to have communication with the police and get in trouble, obviously. And I was not doing what I was supposed to, but it's not an excuse. I'm not making excuses for any of it. I'm just telling you what happened. And they recently threw that case out and nollied it. It's not even a case anymore. So I need help with a lot of things, but prison is not one of them. I swear to you, I'm not out running the streets and committing all kinds of crimes and being a menace to society. I'm just having addiction issues and codependence issues and issues with my environment and just being stable. I was with the same woman for 17 years and I didn't have to do anything. I just had to work and come home. And she took care of everything. So that's a blessing, but at the same time, it's a curse for me as well, because I wasn't able to learn to do those things on my own. So yes, I do need help very much so. And I really hope that I can find the help and trust in people to help me rather than go to jail. I appreciate you, Ms. Montoya, for being patient with me at that time. Like I said, I thought you were gonna lock me up, and I'm sorry I misread you. And it won't happen again.
Thank you.
I had a halfway house waiting for you. We waited for 2 weeks.
Yeah, I know you told me that, and I feel stupid for even knowing that now, because I thought you were just gonna lock me up, and I'm sorry for misreading and misjudging you. And it's probably because a lot of people told me that you were real tough, and it just was in my head. You're right. I make up things in my head, and I automatically think everyone's out to get me. It's probably due to long drug use, but I need help. Like I said, I need help. I need help with a lot of things, but prison is not help. You know what I mean?
Okay. Well, thank you. I appreciate your statements.
One more thing, please.
Yeah.
If anybody, I mean, like I said, there's a clinician I'm working with. She's a behavioral analyst out of Cheshire. She's doing pro bono work for me, and if possible, if it helps, I'd like to give her name, and maybe if it's going to help me in any way.
This is regarding your parole violation hearing right now. So we're not at that point yet where we're doing. Okay. That's good for you to be involved in anything you can at this moment and continue doing that for yourself. Yeah. But that doesn't really pertain to your violation right now. So. Okay. So what I'm going to do next is I am going to announce my findings. So I'm going to be right with you with that.
They did, like I said, I think, they did dismiss the case. The case is up. The arrest is out.
Okay, so I'll explain how that works when I'm done with this part, okay?
I gotta explain one more thing, I'm sorry.
I have that noted.
I gotta explain one more thing, I'm sorry, I just remembered.
What?
No contact with my co-defendant. She is not my co-defendant, so I don't know how that's even possible, but I went to my son's graduation and his mother happened to be there. And I had permission from Parole to go to my son's graduation. His mother happened to be there. We took a picture and I left. I went directly to Parole and showed her the picture. That's how she's seen it. I showed her, I let her know what happened. I was totally legit on all that. And now I got a misconduct for it and I don't understand. And she's not my co-defendant. We've never been arrested.
Well, you know you're supposed to have any contact with her. It's written there, you signed it, you read it, there's no contact. It doesn't matter if it's for 5 seconds or for 5 hours. You understand what no contact means. So I appreciate your statements though. So what I'm going to do next is I'm announce my findings now. I will note on the record, as previously stated, this is your 4th parole violation on this term of special parole, and you were in the community for less than 4 months before you returned. So I am going to On charge 1, I make a finding of probable cause, release direction reporting. This is based on evidence and testimony that was presented in support of the violation, which is Exhibit D. On charge 2, I make a finding of probable cause on program participation. This is based on evidence presented in support of the violation, Exhibits S and T. I make a finding of probable cause on charge 3, condition residence, based on evidence and testimony presented in support of the violation, which is Exhibit D. I make a finding of probable cause on charge 4, conditional bail laws abuse to the law. This is based on evidence presented in support of the violation, Exhibit E. On charge 5, I make a finding of probable cause on bail laws drugs, based on evidence presented in support of the violation, Exhibits F through Q. There's no findings on alcohol use in regards to the drug charge. I make a finding of probable cause on charge 6, condition, no consumption of alcoholic beverages, based on the evidence that was presented in support of the violation, which is Exhibits B, F, G, and N, with a no finding on the cocaine use regarding the no consumption of alcoholic beverages for that charge. On charge 7, I make a finding of probable cause, no contact with co-defendant, based on the evidence and testimony presented, which is Exhibits B and R. And on charge 8, I make a finding of probable cause mental health treatment based on evidence presented in support of the violation, Exhibits B, S, and T. And I do find the act is serious enough to warrant revocation. I've told you should be detained while you wait for your revocation hearing. So at the rev hearing, myself or another hearing examiner will determine if you violated conditions of your parole. If so, the hearing examiner will make recommendations regarding whether the parole should be revoked, whether any sanctions should be imposed. So if your charge is not laid, then I'll receive an addendum eventually from your officer, and then we're going to go ahead and schedule your revocation hearing, and then that's when we determine what's going to happen. I'm sure you're aware of the process. Do you have any questions about that?
No, I don't.
Okay, so we'll see you soon for your revocation hearing then.
Oh, you're not going to tell me the date now?
No.
Okay.
I will complete the addendum today.
Okay, so then
Montoya,
you'll get
I
notification when it's scheduled.
All right. I apologize to you, Ms. Montoya.
Thank you, Shepard. Best of luck.
Right. So you're all set today, sir.
All right. Thank you.
Thank you. Thank you, P.O. Montoya. I'll see you in a little bit.
Okay.
Have a good day.
Good morning, Mr. Hughes.
Good morning.
Morning, we're here today for your preliminary hearing.
Okay.
Hello. Buenos dias. I'm done right now for with all the stuff that I need to get ready, so I'll be on for a bit. Let me turn on my camera. Ya estamos.
Good morning, I'm Parole Officer Meisinger, hearing examiner for the Board of Paroles and Paroles. This is a preliminary hearing concerning Hughes William, number 281675. Today is October 8th, 2024. This hearing is being conducted via video at the BOPP Central Office, New Haven Correctional Center. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state me your full name and DOC inmate number for the record?
William Hughes, 281675.
You new counsel here today? Please identify yourself.
Attorney Alfonzo, Sirica, Public Defender with the Parole Revocation Unit, on behalf of Mr. Hughes.
This is a preliminary hearing, which is the purpose under Connecticut law. It's to determine if there is probable cause to believe you commit an act that violated the conditions of your parole, determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which is releasing you and place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charges state your PL is bringing against you. I will review identify exhibits filed for the record. Counsel will then have an opportunity to just issue probable cause in the spirit of the allegation. At the conclusion of the hearing, I'll inform my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure?
No.
Okay. You,
State case.
Did anybody catch his name?
Yes. yes. You have important rights in this hearing, which I'll now review with you. The right to have an attorney present. You have counsel here. You have the right to receive the written notice of charges violation. Did you receive the written notice?
Yes, I did.
You have a right to view the evidence against you. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so we now review the charge, state appeals bringing against you, and the information underlying each charge. So charge 1 under obey all laws. You're charging officer reported, Pennsylvania Parole Board conditions governing parole, reparole, comply with all municipal, country, state, and federal criminal laws, as well as provisions of the vehicle code and liquor code. You shall abstain from unlawful possession or sale of narcotics and dangerous drugs, and abstain from the use of controlled substance in the meaning of the Controlled Substance Drug Device Cosmetic Act. Without a valid prescription, refrain from owning or possessing any firearms or any other weapons, refrain from any assaultive behavior. Obey all laws, to the best of my ability, fulfill all my legal obligations, including payment of all applicable child support and alimony orders. I'll notify my PO within 48 hours of my arrest for any offense. I will not use or have my possession control any illegal drug, narcotic, or drug paraphernalia, firearms, ammunition, or any other weapon. My chance to request acceptance for parole supervision is based upon the premises that there is a reasonable probability that I will live and remain at liberty without violating the law, and that my actions are not incompatible with the welfare of society. In the event that I engage in conduct in the future which renders this premises no longer valid, then my parole may be revoked or modified accordingly. On 1/3/24, William Hughes was most recently released from custody stemming from parole violation in November 2023. Ms. Hughes went over the interstate parole supervision conditions of his release in detail. Parole officer spoke in detail Mr. Hughes' expectations, rules, curfew, and conditions. Upon release, Mr. Hughes resided with his friend Naugatuck. Mr. Hughes remained with full-time employment until recent arrest on 9/20/24. On 9/20/24, a parole officer was contacted by Naugatuck Police Department regarding Mr. Hughes' involvement in a road rage incident that took place in Naugatuck. Per report, Mr. Hughes was said to be driving his vehicle erratically along city streets. At one point during the incident, Mr. Hughes was said to be waving a knife at the other driver. When Naugatuck police officer asked Mr. Hughes about the knife, he stated he did not have one on him or in his possession. Mr. Hughes refused to let officers search his vehicle when asked to do so. Due to Mr. Hughes being on parole supervision, a search was lawfully conducted on this vehicle. A knife matching the description given by the operator of the other vehicle was found sitting on the passenger seat of Mr. Hughes' car. Due to the aforementioned information, Mr. Hughes was placed under arrest and charged with threatening second, breach of peace second, reckless endangerment second. A parole remand to custody was lodged from Naugatuck Police Department. And the state is following exhibit pre-marked for identification purposes as Exhibit A, remand in custody order. B, signed copy of Connecticut consists of interstate parole. C, Commonwealth of Pennsylvania notice of board decision. D, signed copy of Pennsylvania board parole conditions governing parole, reparole. And then I relabeled this as E for both Connecticut interstate parole violation report and notice of interstate parole violation. And G is Naugatuck Police Department report, and H is photographs. Did you receive notice of parole violation report, and the other items I marked? Did you review them?
Yes.
Do you need to continue to any departments? We have no witnesses, so it's now defense's opportunity if you'd like to testify with respect to probable cause and severity.
Yes, I'll make some brief statements. I did speak to my client September 27th, and I did go over the interstate procedure with him. I know it's a little bit different for the establishing of the probable cause when it's an interstate case, but Exhibit G is written here, it's the Naugatuck Police Department report. Does indicate that the other individual is the individual who got in front of my client's car. They did exchange some words, but the other individual is the one that got out of the car. My client reversed and drove off in that particular incident. And he did call the police department on the way. He was heading to the police department. And the other individual was also the one that threatened to shoot my client. Initially, the alleged victim who was arrested also lied to the police until they listened to the dispatch tape, which indicated, and it's in quotes, police said, I clearly heard Matos, the other individual, and quote, give me an excuse to put a fucking bullet in your head right now. Give me an excuse. Give me an excuse. I know there's indication that my client had a knife. There is a picture of that. My client, that knife is, he didn't get charged with a weapon in a motor vehicle. That's the knife he uses for work to open boxes. So there was a knife in the vehicle, but there is a picture of it, and the blade it's a very small blade. Obviously, if it had been oversized, he would have been charged with the weapon in a motor vehicle. Also, in the police report, page 4 of 6, the other individual pulled in front of my client where my client had to stop, and the other individual is the one that got out of the vehicle and started yelling at my client. My client did call the police, which smartly, and he was actually heading to the police department because he didn't want to go home because he was being followed. I also want to note that the parole officer did indicate he was released in January, so he's been out for about 8 months from parole. Resided with his friend in Naugatuck, remained with full-time employment until his arrest on September 20th of 2024. After reading this police report, I'm not sure what else Mr. Hughes could have done but call the police and not engage. Never got out of the car. He tried to drive away, and the other individual followed him.
Thank you. Right, so listen to testimony. I've reviewed the evidence submitted by the state. I will note there is a previous parole violation. No conducts were received. Thunder was on parole for about 8.5 months before he received this new arrest. It is an interstate case with Pennsylvania. So just to note that. So I'm going to announce my findings, and I do make a finding of probable cause on charge 1, obedience to the law, based on the evidence that was presented in support of the violation, which is exhibits G, H, and F. So what we're going to do is we're going to submit this information to the state of Pennsylvania regarding your hearing, just saying that there's probable cause. You did receive a new arrest, and then it will be up to Pennsylvania and our interstate unit to decide when your release will be. I'm not sure when court is. We have a court date.
Yeah, I have it. I have October 25th.
October 25th. So we're going to give them the information, and then they'll decide when your release will be and where you're going to go. Okay? All right.
Good luck, William. I just wanted to put those things there in the police report. Hopefully it plays out in court.
Can I catch your name again?
Alfonzo Sirica, S-I-R-I-C-A. Just talk to the counselor. You still at New Haven with Kitchen Harris?
I am. I'm in New Haven. I'm in the dorm now.
Okay.
Counselor.
They have my information. Just tell me you need to reach Sirica at the Parole Revocation Unit.
Thank you. Will you be helping me on the 25th for the court date?
No, you'll have a different attorney for court.
Somebody else.
Represented you on this one, okay?
Gotcha. Okay.
All right. Good luck to you.
Thank you.
All right. Good luck, sir. You're all set.
Thank you.
You're welcome.
All right, I'm trying to set up this other stream here so I could do a double stream, and then I'm gonna try to set up one for, I'm not sure if it's gonna be Utah or Iowa. I'm gonna check if I could pull it off. We'll see how that plays out.
Good morning, sir. Mr. Grant.
How you doing?
Good, thanks. We're here for your preliminary hearing today. So we're going to get started with that, okay?
Yep.
Good morning. I am Officer Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Grant Tevin number 371813. Today is October 8th, 2024. This hearing is being conducted via video at the BOPP Central Office, New Haven Correctional Center. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state to me your full name and DOC inmate number for the record?
Yes, Tevin Grant, DOC number 371813.
Thank you. This is a preliminary hearing, which is the purpose under Connecticut law. It's to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, and release you and place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is a reversal proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure. I'm going to read you your rights. Then we will review the parole violation charge to state your appeal is bringing against you. I will review and identify exhibits filed for the record. You will then have an opportunity to just issue probable cause in the spirit of the allegations. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure?
No.
Okay. You have important rights at this hearing. You have the right to have an attorney present. Do you want to continue without counsel?
Yes.
Okay. You have the right to receive the written notice charging the violation. Did you receive the written notice?
Yes.
You have a right to view the evidence. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
So you now review the charge, the state your appeal is bringing against you, and the information underlying each charge. Charge 1 under bail law, the obedience of the law. Your charging officer reported at 9:24:24, approximately 8:10 p.m. You were called to supervisor of the MJ Payne's office. She asked you for your discharge paperwork from the hospital. You told her you did not have any discharge paperwork. Supervisor Lecture Payne then instructed you to go to the front office to see COD Rayner so that he could give you a breathalyzer. You asked her why you needed to take a breathalyzer. She explained to you that it is halfway house protocol to render a breathalyzer and urine on anyone that is returning from the hospital. You then walked out of her office and stated, "Fuck this place, I will blow this place up with all the staff in it." Supervisor Lecture Payne asked you if what you said was a threat, and your response was, "Shut up, you're emotional." Supervisor Lecture Payne then told you that she doesn't take threats like this lightly and that she was going to report it. Halfway house staff contacted 911 and Waterbury Police responded to the halfway house. And upon conclusion of their investigation, based on the facts and circumstances, you were arrested and charged with violation of the following Connecticut General Statutes, threatening in the second degree. This matter is pending in Waterbury GA4. And the state has filed the following exhibits that are pre-marked for identification as: Exhibit A is notice of parole violation. B, notice of parole rights. C, remand to actual custody. D, PCS signed conditions. E, DOC halfway house agreement. F, DOC incident report. G, Waterbury Police Department case incident report ending in 619. H, parole violation report. And I is CT judicial case lookup, court date 10/18/24. Did you receive the notice of parole violation report, and the other items I marked? And did you review them? Yes.
Yes.
Do you need to continue this hearing to obtain any additional evidence?
Excuse me?
Do you need to continue this hearing to obtain any additional evidence?
No.
We don't have any witnesses. So now is your opportunity to respond to the parole violation charges against you. Remember, you may remain silent. I'm going to swear you in under oath so you could speak today. Can you please raise your right hand for me?
Absolutely.
You solemnly swear, sincerely affirm, as the case may be, the evidence you shall give in this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yep.
Okay, would you like to say anything at this time regarding the violation?
Not guilty.
Yes. I'll just tell you from, my side of the story of what happened in entirety. And I'll let you know why I, had that explosion or, a lash out or whatever. It was a build-up. I've been in the halfway house for 7 months. I've been dealing with a lot when it comes to, because I've been trying to work and I had a job lined up. They weren't trying to allow me to work the job, which, I felt wasn't right because there was someone else working the job that I was trying to work and they weren't allowing me to work. So I felt like they were kind of discriminating against me in a way. I tried to, so this is the incident with the job, and this is the day before this explosion happened. So this is like I said, it's a buildup. When a friend of mine got offered a job to work in Stanford to be a delivery driver, and he was granted the job by Gerard, parole officer of the halfway house in Waterbury. I then went and applied for the same job, and I was denied the opportunity. I had nothing preventing me from working the job. My license is valid. You know what I mean? I wasn't on any restriction in the house or anything like that. And this is the second time they denied me for this job, and they allowed 2 other people to work this job, but they didn't allow me to work the job. So I didn't understand that. And then the day of the incident, I went to the hospital, like it said in the report, which that's correct. I went to the hospital. I got a checkup there. I let them know that I was going to be late, and I had the nurse call the halfway house and let them know I was going to be back at the time that I was scheduled to be back on my schedule. And they were cool with that. I didn't know I had to bring back the discharge paper because I'd never been to the hospital since I was in the halfway house. I didn't know that was a requirement. I was never told, never told that. So I had no knowledge of that. And on my way home from the hospital, I threw the papers away. I then, went home. They told me, that I needed that paperwork, and I then called the hospital to see if they could fax over the paperwork. They said it was against their policy. So they said that I would have to pick it up in the morning. I never made it to the morning because I got arrested. Well, when I first got into the house, they asked me for a urine. I gave them a urine. I complied with that. Afterwards, which was like hours later, they asked me for a breathalyzer. And I'm like, this is something new. I have no knowledge of again. So I was, I was questioning it. I was like, when did they start doing this? It's like, oh, it's a new protocol for parole. Like I said in the report, Alexander, she's not lying. That's true. And, it kind of rubbed me the wrong way because I've never gave a dirty urine. I never gave, I've never been late back home without calling and letting them know. They've never had a problem with me as far as tardiness or anything or any dirty urines like that. So I kind of felt insulted with that, but I get it's protocol. But, I had a frustration because it just felt like every day there was new rules being added on into the halfway house. And like I said, I was already upset about the discrimination against the job, all the other things that going on in the house. Like the house is inhumane. There's a lot of black mold in the house and shower and things like that all around the house. So I wasn't in the right state of mind dealing with that. There's a lot of people sick in that house. A lot of employers that were sick. They don't have the proper air facilitation through the house. There's a lot of germs in the house. They haven't cleaned.
Germs.
They don't clean like for instance.
All right, no, I hear that. I want to hear about the incident, the part of why you got arrested.
Everything in the incident report is true, but I would say this is what I said as far as the explosion. When I walked out, me and Alexander, we had our words exchanged. I felt like she kind of gave me an attitude, or she just was kind of careless about the situation, which kind of rubbed me the wrong way, which I should have had more self-control, but I was in the hospital waiting in there for 4 hours. I was tired. I was out of the house because I'm in school. I was in school. So I leave the house at 6:30 in the morning, and I'm gone pretty much all day. You know what I mean? So I really don't get much sleep. But anyways, not to make any excuses. I said what I said. It's true. And that's just what it is. I'm willing to man up and, take responsibility for what I said, and whatever consequences you guys decide, that's what it's going to be.
That's what it is. What else can you
Thank
say? You can't deny that.
I appreciate your comments, and I've noted what you said. So what I'm going to do next then is I'm going to announce my findings. So I do make a finding of probable cause on that charge 1, obedience to the law, based on the evidence and testimony that was presented, exhibits F, G, and I. And I do find the act serious enough to warrant revocation. I've determined to detain while you wait for revocation hearing. So at the rev hearing, myself or another hearing examiner will determine if you violated the conditions of your parole. If so, the hearing examiner would make recommendations regarding whether your parole should be revoked, what any sanction should be imposed. So after you get this case disposed of, we bring you back and determine if there's a parole violation or not. Okay? So I'll see you when that charge is done.
After I go to court?
Yes, after it's disposed, I bring you back, and then we determine if there's a violation or not.
Okay, can I just say one more thing? I just want to say I don't care if this make a difference in your decision or not. I just want to say that I didn't mean what I actually said. It was an overwhelming emotional thing.
Well,
I was overwhelmed.
I understand what you explained. I understand that.
When she asked me that, I did say you're emotional, and I told her to shut up. But I also told her that I didn't mean what I said. She knows, because me and her had like a personal relationship. I thought at the where we had to understand.
You just have to know that you can't say certain things.
I know that.
So it's about better choices when you get angry. I get it. I understand what you're saying.
I want to also say that I know I have anger issues, and I've been in anger management, and I've taken therapy for it, and I completed it. Which I don't know if I need medication or not. I don't know if I can't determine that for myself. Obviously, it has to be a professional. But I do want to acknowledge that.
Okay, I appreciate it. And then that's the stuff we'll discuss more at your rev hearing.
Okay.
Okay.
Like
so I'll see you soon as that's taken care of.
All right. Thank you.
Okay, good luck, sir.
Man, hey, what outcome could he expect after what he said? I can't even repeat what he said. Oh, man. All right, so it looks like we got to wait here for a moment. They put us up on, they're getting the other individuals ready. How's everybody doing out there? And for those of you wondering, I'm doing a double stream right now. I'm doing both platforms. If you're not familiar with the platform, oh, you know what? I didn't even put this up on the screen. Give me a moment right here. Let me see here. Enhance. Stickers. Bam. Okay. Let me see.
Good morning.
Buenos dias.
Good morning.
Good morning.
You can hear us, sir?
Yes.
Okay, great. So Mr. Pierelli?
Yes.
Good morning. We're here today for your preliminary hearing.
Mm-hmm.
Okay. We're going to start that. We'll be right.
What does that mean, a preliminary hearing? What is that? Is that like before I go to court? Is that what that means?
Sir, when we discussed this the other day, the preliminary hearing is to decide whether or not there's probable cause for the allegation, the charge, to go forward and continue to hold you on the remand before the revocation hearing. It's a due process protection to make sure your parole officer didn't just remand you for absolutely no reason at all. It's your right, your protective right, for a neutral party, this hearing examiner, to review the allegations to say, okay, did they just remand him for no reason at all? Okay.
And I'll be right with you. I just have to call the parole officer is participating.
Are all three of them going to be present?
No.
All right, Mr. Pierelli right here. James, we've seen this. Not, I don't know. I don't think so. I don't think I've seen him before, but I'm not sure. He looks agitated. That build cool things. Hey, and over there, everybody over there on the TT side, shout out to you guys. Everybody that's over here on the other streaming platform with the red logo.
Good morning, Officer McNeil. Parole Officer Meisinger.
Good morning.
Good morning. So we have Mr. Turley here as well as Attorney Famiglietti. So we're going to begin this case. Are you all set to begin?
Yeah.
Okay. Good morning. I am Parole Officer Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing starting Pierelli Thomas, number 393241. Today is October 8th, 2024. This hearing is being conducted via video at the VOPP Central Office, Bridgeport Correctional Center. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state for me your full name and DOC inmate number for the record, sir?
Thomas Pierelli, 393241.
Thank you. We have a parole officer present. Can you please identify yourself for the record?
Officer Crystal McNeil.
Thank you. We have counsel here today. Please identify yourself.
Yes, good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit.
Thank you. This is a preliminary hearing, which is the purpose under Connecticut law. It's to determine if there is probable cause to believe you commit an act that violated the conditions of your parole, determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause or reinstate your parole, means releasing you, place you back on parole supervision. If I find probable cause and determine that the act is sufficient serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. This is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your PO is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to just issue probable cause in the spirit of the allegations. After the state is finished, you will have the same opportunity. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
Okay. You have important rights at this hearing, right to have an attorney, and you have an attorney here today. You have right to receive the written notice of charges of violation. Did you receive the written notice?
Yeah, yes, I did.
You have a right to view the evidence against you. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to move forward?
Yes, I believe so.
Okay, so we will now review the charge the state your parole officer is bringing against you and the information underlying each charge. So, P.O. McNeil, if you could please read the charges.
Okay, charge 1 is for reporting. On 9/10/24, you were directed to report to New Haven Reach on 9/13/24. You never reported to Reach over the weekend, but instead stayed at the rooming house in Waterbury. On 9/16/24, you were directed to touch base with the New Haven Reach case manager and report back to New Haven Reach. In the afternoon, you were also directed to report to New Haven District Office and P.O. Monroe on 9/17/24. On 9/17/24, P.O. Monroe contacted Reach case manager at 8:45 a.m. who stated that you never showed to Reach the night before. P.O. Monroe contacted you and you stated that you were still in Waterbury at the room house.
Yes.
And did not. I'm sorry?
No, there's
No,
definitely
the CO
you can
came
continue.
Rooming house and did not go to New Haven Reach as previously directed. This is a violation of failure to report. Charge 2, GPS. On 1/22/24, you were instructed to submit to GPS monitoring and comply with all monitoring requirements. You read, acknowledged, and signed the GPS agreement. On 6/23/24 at 3:27 a.m., your GPS battery shut down and was not powered on again until the next day, 6/24/24 at 10:17 a.m. You were unaccountable in the community for almost 7 hours. This is a violation of the GPS agreement. Charge number 3, obedience to the law. On 9/18/24, you were involved in a hostile altercation, engaging in violent, tumultuous, and threatening behavior towards Maple Street halfway house staff. This behavior resulted in Connecticut State Police and Bridgeport PD responding to the halfway house, subsequently leading to your arrest for Connecticut General Statute 53A-181 breach of peace. Charge number 4, halfway house placement. On 9/18/24, with the intent to cause annoyance and alarm, you engaged in violent, tumultuous, and threatening behavior towards staff at Maple Street halfway house. Your actions violated the DOC halfway house agreement. I will treat others with respect and not engage in verbal or physical altercations with other offenders, staff, or third parties.
Thank you.
That's all the charges. Yep.
Thank you. And the state has filed the following exhibits that are pre-marked for identification purposes. Exhibit A, arraignment in actual custody. B, special parole conditions. C, notice of parole violation. D, notice of parolee rights. E, parole violation report. F, misconducts 2, dated 6/26/24 and 9/17/24. G, halfway house incident report. H, halfway house agreement. I, GPS agreement. And J is police report. Did you receive notice of parole violation report, and the other documents I just marked? And did you review them, sir?
Yes, I did.
You need to continue this hearing to obtain any additional evidence.
No, we do not.
We don't have any witnesses today. So at this time, the state will have an opportunity to make a short statement and testify with respect to probable cause in the spirit of the allegations. I'm just going to swear you in, P.O. McNeil, as well as Mr. Pierelli, in case you do speak today. Can you please raise your right hand for me? Mr. Pierelli, can you raise your right hand for me, please? Thank you. You solemnly swear or sincerely affirm as the case and be the evidence you shall give concerning this case should be the truth, the whole truth, none but the truth, to help you God upon penalty of perjury?
Yes.
Okay, so P.O. McNeil, would you like to say anything right now in regards to the violation?
No, everything is there. I have nothing else to add.
Okay. So it's now counsel, if you'd like to say anything at this time, would be your turn to testify.
Yes. I've got no comment as to charge 1 or 2, but as to charges 3 or 4, if we examine closely Exhibit G, and I'll just give the hearing examiner a moment to look at Exhibit G. What's required under obey the law in the halfway house placement, and what's alleged, and what has to be shown, is that my client was involved in a hostile altercation, engaging in violent, tumultuous, and threatening behavior towards the staff. That's what's alleged in both of these parts. My client made 2 brief comments in Exhibit G. That's it. Mr. Pierelli, how long had you been at the placement prior to being placed at Connecticut Renaissance for a day?
So I was in the process of moving to the apartment in New Haven.
How long have you been on parole?
I've been on parole for almost 4 years.
Okay. And this is your first violation, correct?
Yes.
So my client had been working. How long had you been working when you were placed in the Renaissance at the same place?
I've been working for almost 4 years. The first 2 years, I worked 2 full-time jobs. After that, I worked about a job ever since. I've always had a job since I've been out.
And you drove there, correct?
No, my parole officer wouldn't let me drive there. She told me how to leave my car at the parole office.
No. Prior to going to Renaissance, what was the setup?
What is that Renaissance, the halfway house?
Connecticut Renaissance Maple Street Work Release Program, where this incident allegedly occurred.
Yeah, because I was in the process of moving to New Haven.
Right.
Parole officer McNeil told me that I had to go to a halfway house. I wasn't even there for a day before I was arrested.
I just answered the questions that I'm asking you. How had you been getting to work?
My car, my vehicle.
Okay, and how long had you been driving your car without incident, without any violations of any curfews or anything? How long had you been doing that?
For almost 4 years, give or take.
Okay, and on September 18th at 2:10 in the afternoon, you were called down by the case manager that you were just assigned, and they advised you that you can't drive your car because it's against program rules, yes or no?
Yes.
And unfortunately, you got upset about that, correct?
Yes.
My fucking life. I'm going to lose my job, period. That's all he said. That's not tumultuous behavior. That's not a threat to anyone. That's not violent conduct. The gentleman who had been on parole for 4 years was going to lose his job. And that's all he said. And for some unknown God reason, Parole, the halfway house people decided to call the police. Why? Why did they need to call the police? He was upset. He didn't threaten anyone. He wasn't violent. He wasn't tumultuous. No, he didn't say, I'm gonna shoot up this place. He didn't say, I'm gonna hit someone. He didn't take a swing at someone. He didn't throw a stapler. He said, I'm gonna lose my job. You guys are ruining my fucking life. Which is true. That's the truth. They were going to make him lose his job. He was mad. He has a right to be mad. Human beings have a right to get upset, particularly when someone for 4 years who had done nothing wrong was told the first day of his place, without explanation, you can't drive your car. Did the police need to be called here? He went cooperatively. There's no interfering. There's no resisting. He's been in jail now for how long, sir? Since September 18th, you've been in jail?
Yes.
This is ridiculous. I would imagine the people at halfway houses, the staff, are supposed to be able to learn and know how to manage people's stressful situations. This man's been on parole for 4 years with no problems. Of course he's going to be upset. Of course he's going to react when he's told you can't go to work, you can't drive your car. You're ruining my... He told the truth. I would ask that you make a finding of no probable cause as to disobeying the law for him being upset and not violating the halfway house placement rules. He reacted the way a human being's supposed to react. He didn't get violent. He wasn't tumultuous. He wasn't threatening towards staff. And if you do make a finding, this is certainly not serious enough to go forward with the revocation. We have one GPS violation from 3 a.m. to 10 in the morning where his GPS shut down. He's probably asleep. And then he failed to report.
One GPS, no.
Hold on. I'll let you speak. You can, when he's done, you can speak if you'd like to.
The GPS shut down. He didn't cut it off. This is one. They put the GPS, it says right here, on January 24th, you were instructed to submit to GPS monitoring. 6 months later, it's down and not powered on until 10:17 the next day. Okay, is that serious? No. And then he failed to report one time. I'd ask that you find that this violation is not serious enough to go forward with a revocation hearing. It's not even, all violations you can argue are serious, but the legislature has required it be sufficiently serious. So more than just serious. Thank you for your time and consideration. Let's let this man get back to work.
Thank you.
Get back to work.
Neil, did you want to say anything else before I announce my findings?
Put him in a wood chipper.
I'll just know, as far as the GPS, excuse me, Pierelli knows that he's had multiple GPS violations, and I let him go. So, yes, I did charge him with the one GPS after so many times. And two, I'm just going according to the halfway house report, where it states that he was clenching his fist and stepping into their personal space in a threatening manner. I've witnessed his angry outburst, so I can imagine. So again, just going by the report, that's where that language came in.
Look at him crossing his arms.
Just briefly to respond. 4 years of supervision.
Go ahead.
4 years.
Not enough.
Supervision. Balling your fists when you're yelling. Look at me in the screen here. Balling your fist at your side when you're yelling is not balling your fists. Putting your dukes up is not balling your fists. And being in they're in an office. Being in someone's personal space is not violent, tumultuous, threatening behavior.
Could be perceived.
It is, it is not. And I don't care how it could have been perceived. We have to take the conduct, and any prior GPS violations that aren't in this report are irrelevant. Any prior conduct
Well, it is I mean, aggregating information, so I do take it into consideration.
Okay.
But
over the course of 4 years. Thank you.
Thank you. Well, I appreciate everybody's statements. So I'll be right with you with my findings.
So this guy, he attacked a little girl. I can't say the word on here, but he's all bad. Back in 2000, when was it? It was in 2000 and let me see here, November 2014. So I for public safety, hey, keep him, throw away the key, and like Lolly said over here, a one-way ticket to hell. All aboard, and drop him off there, and no returns. Return to sender.
So
is no bueno.
I'm going to announce my findings. So on that charge one, I make a finding of probable cause, police direction reporting based on the evidence presented in support of the violation, which is exhibits E and F. I make a finding of probable cause on charge 2, GPS, based on the evidence presented in support of that violation, I and F. On charge 3, I make a finding of probable cause, obedience to the law, based on the evidence presented in support of the violation, G and J. And I make a finding of probable cause on charge 4, condition halfway house placement, based on the evidence presented in support of the violation, G, H, and J. I've also taken into consideration testimony that was provided today by both sides. I do find the acts are serious enough to warrant revocation. I plan to be detained while you wait for your revocation hearing. So upon disposition of these charges, we bring you back and then we determine if there's a violation or not. So after these get disposed, I'll be notified and then we bring you back and then we determine if there's a violation and what, if any, sanction is warranted. Do you have any questions, sir?
Yeah, well, just on the record, I worked the night shift. So that's why my GPS was a failure at that time.
Well, you can make your
I just
statement.
want to let you know, I worked the night shift, so that's why I was off that time. And then as soon as it turned back on, I called my parole officer.
Okay, so at the rep hearing, you're going to have a chance to say those things as well. Whatever else you want to add, bring that at the time of the rep hearing. Do you have any questions?
Next.
Once your case is disposed of in court, like we hope it's going to be disposed, they will set up a hearing. It's up to parole to set that hearing up. And then I will give you a call. We'll discuss the revocation hearing and you'll hear from our social worker. Okay, sir? You have a very nice day, sir.
Have a good day. We'll see you soon, sir. You're all set for today.
Get out of here. Get out of here. Go back to your cell. Human waste. Right there, getting up. Acting like he's like the victim. Come on now. And for those of you that are interested in what I'm speaking about, just look his name up. You just type in Stanford Man. And what was his first name? Man, what was this? Let me see over here. Thomas. Last name is Pierelli. All right, so right now we're waiting for
Good morning.
Good morning.
All right.
Hi.
Next
So
one's
I
starting
only
up.
have Mr. Jordan.
Yeah.
Jordan.
Jordan?
All right, let me pull up the next individual's name right now, and I'll get that information over here for
Good morning, Mr. Jordan.
Good morning.
Morning. We're here today for your revocation hearing, so we're going to get started with that, okay?
All right.
Good morning. I am Parole Officer Meisinger, hearing examiner for the Board of Pardons and Paroles. This revocation hearing concerning Jordan Kendell, number 435356. Today is October 8th, 2024. This hearing is being conducted via video at the BOPP Central Office, and the Osborn Correctional Institution. This is a public hearing, and public access. This hearing is available via video live stream. Can you please state for me your full name and DOC inmate number for the record?
The screen went out. The screen went out. I couldn't even hear what you said.
Can you please state for me your full name and DOC inmate number?
Oh, Kendell Jordan, 435356.
Thank you. We have a parole officer present. Can you please identify yourself for the record?
Good morning, Catherine Montoya.
And we have counsel here today. Can you please identify yourself?
Yes, Public Defender Robert Famiglietti of the Parole Revocation Unit.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing you and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. This is the procedure for today. I'm going to read you your rights, and we will review the parole violation charge and state your parole officer is bringing against you, and we'll review and identify exhibit file for the record. The state will then have an opportunity to present a relevant testimony. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure?
No, I don't.
You have important rights today. Your right to have an attorney present, and you have counsel here. You have a right to receive the written notice of charges of violation. Did you receive that written notice?
Yes, I did.
You have a right to view the evidence against you. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to move forward?
Yes, I do.
All right, so you now review the charge, state your parole officer is bringing against you, and the information underlying each charge. So P.O. Montoya, can you please read the charges?
Charge 1, obedience to the law. On 1/25/2024, Waterbury Police conducted a traffic stop. You were the passenger. Waterbury Police asked you to step out of the vehicle and conducted a pat search. While conducting the pat search, Waterbury Police found a bag filled with rice bundles, with rice and bundles, with small square pieces of paper, which are commonly used to pack heroin to sell at street level in your interior right jacket pocket. Waterbury Police retrieved a yellow bag from your interior right jacket pocket and found 190 white glassine bags, each stem man down, each containing a 10 powder-like substance. 90 glassine bags, each stem panic, each containing a 10 powder-like substance. 24 glassine bags, each stem north face, each containing a 10 like powder substance. A clear knotted plastic bag containing a white rock-like substance that weighed 2.5 grams. A black digital scale with white residue on it, and clear plastic sandwich bags. Waterbury Police also found a small blue Ziploc bag containing 3 colorful pills in your exterior right jacket pocket.
Damn, he was a pharmacy on
These
wheels.
These pills were consistent with the appearance of MDMA ecstasy and were packed for street-level sales. Waterbury Police tested the 10 powder, and it was positive for presumptive presence of heroin, and the white rock-like substance was positive for presumptive presence of cocaine. You were subsequently arrested and charged with 2 counts of sale of controlled substance of non-narcotic and 1 count of possession of hallucinogen substance with intent to sell. Charge 2. On 10/24/2023, you submitted a toxicology screening at Waterbury Parole. You tested positive for amphetamines and methamphetamines. You signed a voluntary drug admission form. On 11/21/2023, you submitted a toxicology screening at Parole. Waterbury Parole, you tested positive for amphetamines and methamphetamine use. You signed a voluntary drug admission form.
Thank you. And the state has filed the following exhibits that are pre-marked for identification purposes. Exhibit A, remand custody order. B, parole condition. C, parole violation.
What do you guys
report.
think?
D, notice of parole violation. E, Waterbury Police Report, number 8247, dated 1/25/24. F, misconduct report. Voluntary admission form and premier biotoxicology results, dated 10/24/23. And Exhibit G is misconduct report, voluntary admission form, and premier biotoxicology results, dated 11/21/23. Did you receive notice of parole violation report, and those other items I marked? Did you review them, sir?
Yes, I did.
In counsel, has filed the following exhibit that is pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No, we do not.
Okay, we have no witnesses today. So what I'm going to do right now is I'm going to swear in P.O. Montoya as well as Mr. Jordan in case you do speak today. Can you please raise your right hand? You solemnly swear or solemnly affirm as the case may be, the evidence you shall give during this case should be the truth, the whole truth, and nothing but the truth to help you God upon penalty of perjury?
I do.
Yes.
All right, so P.O. Montoya, would you like to say anything at this time?
Yes, good morning. So I've had Mr. Jordan for about 14 months of supervision. He was doing well. He was working. He's on dual supervision with a federal probation officer out of New Haven called Mark Cimino. In November, we did a random urine, and he tested positive for ecstasy. And he was honest. You know, he was partying a little. He was hanging out with the wrong people. Like I said, I have completed successful supervision with him before. Of course, I'm working with him. I referred him to McCall Foundation for treatment. He started treatment. He wasn't like really happy, but he complied, just so, you know, we're clear. Then he came back again for another urine. He was positive again. He is, it took a while for him to admit it, but he finally admitted, you know, he, again, it's just, he started off really good and really focused, and little by little, he started kind of like getting off the path, hanging around with the wrong people, getting a little too comfortable, you know, out there, and it eventually culminated with him doing this, the actual arrest in which he was found with all these drugs. Overall, he lived in a stable household. His sponsor is a lovely lady, very nice to us. I have no issues with him going back to her or anything. My concern is that he went back to what he's doing time for right now, which is drug sales, which was his on dual supervision with the feds. And he is facing a massive amount of time on that end. If he was struggling with money, or if there was an issue that maybe we could have talked about it, I wish he would have come to the table and discussed it with me. I just don't understand. His life was going great. He was working full time. He, aside from the drug use that he had, that he was addressing, things appeared to be very stable at the house. His wife was pregnant. It was a very happy time for him. This was catastrophic in their lives, this arrest. And I just don't understand why it just doesn't stop. He is a terrible drug dealer. He keeps getting caught. This is not the line of work that he should pursue. And I have encouraged him to try to find a skill set for him to be able to just finally leave all of this behind and build a family and do the things that he needs to do as a law-abiding citizen. I reviewed the list of exhibits, and the only thing I find is that he did not finish Renato McCall Foundation successfully. That's the only thing that I have an issue with the list of exhibits. The end says that he completed Renato. He did not, due to the arrest. He did not complete it because he was arrested. Not because he abandoned treatment or anything, he was just arrested. So that's the only issue I have with this. Other than that, this list is pretty accurate. So,
Thank you. I appreciate it. Counsel, you like to say anything in regards to the violations at this time?
Yes, there was an addendum, correct?
Yes. The addendum, thank you for that. PCS did submit an addendum, and the addendum did report on 9/11/24. All these charges were dismissed. The offender does have a federal detainer with a VOP that is pending at this time. So now I'm going to turn over to counsel.
Thank you. As to the preponderance standard regarding charge 1, the charges were dismissed because of insufficiency of the evidence. This was a bad stop. There's no basis to go forward. The government had to dismiss the charges, and as a result, the defendant can swear under oath that these never happened, that the conduct did not happen. I understand that this should be taken into consideration, and as such, there is no evidence. It was dismissed. Thank you for that time and consideration. All we're left with, in my estimation, are 2 positive urines back in November. This incident occurred almost a year ago in January. He's been held for the past 10 months. No other misconducts other than for the 2 positive drugs. So I'd ask, since the charges were dismissed, that no finding be made as to charge 1.
Thank you.
Man, he ain't going nowhere.
So I'll be right with you with my findings.
How is everybody doing today? Hopefully you guys are having a good day. I woke up this morning nice and early to get these streams going. I got 3 streams going. We got Connecticut, Vermont, and a new one from Pennsylvania. But those other ones, they seem kind of boring. So we're right here in Connecticut right now. We'll let the other 2 drive on their own, and I'll be here participating in this one. And if you're new here, if you want to see the visual, or you want to see the individuals, you want to see some of the news clippings or whatever that I'm putting up, if you go over here to this platform here and you type this in right here in green, if you go to this red icon.
So regarding charge 1, I'm going to make a no finding due to the charges being dismissed by court, not being prosecuted. On charge 2, I do find you violate conditional bail laws, drugs, based on the evidence that was provided in support of that charge, exhibits F and G. So that includes the fact-finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. This purpose part of the hearing is to help determine what outcome I will recommend. P.O. Montoya, I don't know if you wanted to add anything
I just want to add, I know he's been down for 10 months. It doesn't matter to me whether there was a finding or not in the court. I know what he was doing, and I am going to ask that you reconsider this line of work, that you go back and either, be a flagger or get yourself a skill set, just all these bad friends that you have, you stay away from them. If you can move out of Waterbury, that would be great. So that's all I'm going to ask, that you reconsider, your choices in the future. And if you're struggling, to talk to your PO and see if there's a way that we can help you. 10 months, he's been down enough. I'm not really asking for more revocation, but I do know that he has pending charges, or like that detainer with the feds. So I don't know how that works. In terms of him being released, I do want to have one clarification. Do you want to go to Reach or do you want to go to your wife? Because this paper wasn't clear.
Well, yeah. let me make a comment. Let me make a comment on your behalf, and then if I don't cover what you want to say, okay, then you can make a comment at the end, summing it up, sir. Okay.
All right.
As to that point, you want to be sponsored by your wife, correct?
Correct.
Okay. So let me just go forward. My client is a single 32-year-old male. He was sponsored at the time by Tanisha Campbell. He wishes to return to be sponsored by her. They share a 6-month-old daughter who was born during his remand. He's very eager to establish a relationship with that daughter. He has another daughter, age 10, who also resides in Connecticut. While he was incarcerated, his mother resides in North Carolina, and his grandmother resides in Waterbury, is ill, and he's also checks on her while he's in the community and is eager to reunite with his grandmother. He was working full-time for Connecticut Traffic Control, LLC, in Plymouth, Connecticut. He worked there, most recently began in November, upon release November, I believe in 2022, correct, sir?
Yes.
My client has done treatment at MCCA in the past. The calls, behavioral health, and as his parole officer stated, that was interrupted at the time of his incarceration. I believe this is his first violation of parole. Is that correct, sir?
Yes.
He wished, while incarcerated at New Haven Correctional, he worked detail and then was also working at Cheshire Correctional in the gym. He wishes to be sponsored, as I stated, in Waterbury, Connecticut, with his significant other, Miss Campbell. Wishes to return full-time with the traffic control, and he is very eager to reunite with his children and bond with his newborn. I think his PO is very insightful. I think she had a lot of excellent comments about his progress and yet some of the bad choices she believes he's making in the past. I have nothing more to add. I'm not sure if my client wishes to say anything at this time.
Do you like to say anything at this time before I make a recommendation?
Everything that was said was pretty much correct. Besides, I worked when I got out of jail in 2022. I worked the whole time, and again, the charges, they were fine. They were dropped or whatever.
Yeah.
So I'm not gonna,
sir. Since you still have the pending violation in federal court, I'd ask that you not address any of the charges because this is all being recorded.
Yeah.
Oh yeah, it's streamed down YouTube and TikTok.
Well, everything with me and Ms. Montoya pretty much was good. She was good to me. I had a good rapport with her. I did have those 2 mishaps. Other than that, I was good. I stayed working the whole time. This is my first violation. I'm just trying to get back reinstated, to get back on my feet, get back to my kids. That's all.
Thank you. I appreciate your statements. I appreciate statements by the state as well as counsel. And I have taken testimony into consideration as well as evidence that is provided by the state. I will note this is your first violation. There are 2 misconducts that were received. You were on supervision for about 1 year and 2.5 months because you went out on transfer parole.
He's going to the
have a
Paroles.
federal detainer. So I do want to put that on the record, as well as the charges in Connecticut were dismissed by the court. So I've taken all of that into consideration, and I am going to recommend that parole be revoked to be reparoled for October 17th of 2024. This is about a 9-month period of confinement as a sanction. I recommend the following parole conditions. No consumption of alcoholic beverages, no contact with your co-defendant, Brian Dawson, Xavier Vargas. I'm going to place halfway house placement on there because you do have a parole to detainer, a federal detainer condition as well. So with that, I put a halfway house placement condition on there. That's only if needed, depending on what happens when you parole to the detainer. I will list your sponsor's information to return to, depending on what happens with your detainer. So do you have any questions about what was said? I am going to submit this to the parole board on October 17th. So the board's going to make the final decision on what happens. So if they do decide to parole you on 10/17, you will parole to your detainer. Do you have any questions?
No, I don't.
Okay. So you are all set for today then, sir. You'll know on 10/17, that's on or after date. I do want to make that clear because you are discretionary parole. It's on or after. So that'll be, you can talk to your attorney as well on that date to find out what happens.
Okay.
Okay. And you will also get it in writing from the parole board in about a week after that if you're still there.
All right.
So give me a call on 10/17 or 10/18 and I'll let you know what happens, sir.
I gotta try to set up a legal call. I just got to this jail. It's like,
I'll set it up.
all right.
All right.
Okay. So you're all set, sir.
All right. Thank you.
Thank you. Thank you, P.O. Montoya. Thank you, Attorney
Thank you,
Famiglietti.
P.O. Montoya.
Thank you.
Hello. Hey, how's everybody doing today? Today we got 3 streams going on, but on the TT side I have one. We got Connecticut. I tend to enjoy these Connecticut ones better than the Vermont or Pennsylvania. They look a bit slow and whatnot. So here we are. We're waiting for the next individual to come on, and if you want to see some visuals, you want to see some news clippings and whatnot, I suggest for you to jump over to this streaming platform right here and typing in this here, and you can see a little bit more. I'll look up the individuals. I'll Google them, and I'll put their information up in the background. And also, if you don't want to miss out on the TT chat, it's also it's on the screen too on this other platform. So just giving you guys a heads
Attorney
up.
Blake, we are running a little behind. I have another case at York I have to go to first.
Okay.
Just so you know, I should be with you right after this case.
Okay, so 15 minutes, 20 minutes?
I'm hoping, yes.
All right, thanks.
Thank you.
All right, and everybody that's coming in, welcome. Highly appreciate you guys. I see we got 68 people on the TT side. On the other platform with the red icon with the white triangle, we got 32 people. So all in all, we got about a little bit under or over 100 people watching. Today, on the TT side, I won't be on that. I'll probably be on for maybe like about another 2 hours or so. Tomorrow, I'll be on a little bit longer. I'm thinking about tomorrow doing some court cases. I don't know. You guys let me know what you guys, how you guys feel about the court cases out of Texas. And we could go ahead and do that tomorrow. If not, then we could go ahead and do some parole board hearings. Tomorrow, we're gonna have Oregon tomorrow. The Oregon ones are really long. So that one I won't be doing on the TT side, but I'll have on the other platform. For sure we'll have Utah, Connecticut, and man, I like the Iowa ones because the Iowa ones they let you know on the spot whether they're found suitable or not. So here we are. How's everybody doing? And hey, where's everybody tuning in from? If you guys don't mind sharing, dropping it in the comment, I'll go ahead and give you guys a shout out. Let's see who just tapped in. We got Andrea. She wrote, "Good morning. Hey, welcome." We got Sedrick. He writes, "Hello, James." Joe Billings coming in from the Harbor area, Carson City. And he's definitely not going to be able to escape those federal charges right there. Let me see here. Joe Billings, Carson, California, all day, every day. Let me see. We got, I can't see that one. Coming in from Mo. Let me see. Hey, we got Pennsylvania. Is it Pennsylvania? PA is Philadelphia, right? No, I don't know. PA all day. Let me see here. We got Nikki from Utah. We got Sedrick from North Pole, Alaska. Woo, whoa. That's what's up right there, man. I got to go ahead and give him one of these for tuning in from Alaska. Let me see who else we got over here. I'm trying to look at the screen over here, but I'm not in the best position. Let me move the chat over here, and I could probably see this a little bit better right here. We got Ernesto coming in from Vegas, Sin City. We got Oxnard, Ventura County, Colonia Chicas. Hey, what's up, Jay?
Yes.
Good morning.
Philly, to be exact. That's right.
Preliminary hearing.
Hello.
Ashley,
I
Arkansas.
have your attorney here, so we're going to get started, okay?
We got Chrissy from the UK. We got Live Without Warning from Massachusetts. Summer Park, VA.
This is a preliminary hearing concerning Bass Jasmine number
And Sacramento for
357723.
Tanis.
Today's October 8th, 2024. This hearing is being conducted via video at the BOPP Central Office, New York Correctional Institution. Can you please state for me your full name and DOC inmate number for the record?
Jasmine Bass, 357723.
You have counsel here today. Can you please identify yourself for the record?
Yes, Public Defender Robert Famiglietti of the Parole Revocation Unit. Good morning.
This is a preliminary hearing, which is the purpose of our Connecticut law. It's to determine if there is probable cause to believe you commit an act that violated the conditions of your parole, determine if the act sufficiently serious to warrant revocation of your parole, and to determine you should be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which is releasing and place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. Please note you've been referred by the Department of Corrections for diversion for substance abuse programming and treatment. If by the end of the hearing I determine you should be held in prison pending further proceedings, I will provide additional information about the diversion process. You should know preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. This is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to just issue a probable cause for the spirit of the allegations. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure?
No.
You have important rights. You have the right to have an attorney present. You have counsel here. You have the right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have the right to review the evidence. You have the right to submit evidence in support of your case. This hearing, you have the right to call and examine voluntary witnesses or cross-examine reverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
Yes.
Okay. So we will now review the charge the state appeal is bringing against you and the information underlying each charge. So under charge 1, drugs, your charging officer reported, I separated this into 4 parts. Part 1, on 7/30/24, on or around this date, you rendered your analysis sample positive for cocaine while at the Rise halfway house. Based on your actions, you're in violation of release direction of bail laws. This is a violation of parole conditions. I will not use or have in possession or control any illegal drug, narcotic, or drug paraphernalia. Part 2 states on 9/17/24, on or about this date, you rendered a urinalysis sample positive for THC and fentanyl at Rise halfway house program. Based on your actions, you're in violation of release condition of bail laws. This is a violation of parole conditions. I will not use or have my possession or control any illegal drug, narcotic, or drug paraphernalia. Part 3 states on 9/20/2024 in the state, you rendered a urinalysis sample positive for alcohol and fentanyl at Yale New Haven Health based on the hospital discharge summary from 10:30 a.m. Based on your actions, you're in violation of release direction of bail laws. It's violation of parole conditions. I will not use or have my possession or control any illegal drug, narcotic, or drug paraphernalia. Part 4 states on 9/20/2024 in the state, you rendered urinalysis sample positive for fentanyl at Yale New Haven Health based on the hospital discharge summary from 5:56 p.m. Based on your actions, you're in violation of release direction of bail laws. This is a violation of parole conditions. I will not use or have my possession or control any illegal drug, narcotic, or drug paraphernalia. Charge 2 under additional condition, no consumption of alcoholic beverages. Your charging officer reported on 9/20/2024. On this date, you rendered a urinalysis sample positive for alcohol and fentanyl at Yale New Haven Health based on the hospital discharge summary from 10:30 a.m. Based on your actions, you are in violation of additional condition. This is a violation of special parole conditions throughout your period of parole. You are prohibited from alcoholic beverage consumption. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, signed special parole statement of understanding and agreement conditions of parole. B, Connecticut Board of Parole remand and custody order. C, notice of parole violation. C, parole violation report. E, notice of parolee rights. F, Rise Women's Program Halfway House Agreement. G, Rise Women's Program Residential Handbook. H, Rise Program Incident Report for Overdose dated 9/20/24. I, Yale New Haven Hospital After Visit Summary printed 9/20/24 at 5:56 p.m. 5 pages. J, Rise Program Incident Report for Medical Summary and 911 Transport dated 9/20/24. K, Yale New Haven Hospital After Visit Summary printed 9/20/24. I, Forensic Drug Diversion Program letter dated 9/19/24. M, Offender Misconduct Report for Positive Drug Screen 9/17/24. And Rise Program Incident Report for Positive Analysis 9/17/24. O, Voluntary Admission for Positive Test Results for Prohibited Substance 9/16/24. P, Offender Misconduct Report for Positive Drug Screen dated 8/15/24. Q, Premier Biotech Lab Report for Positive Urinalysis dated 7/30/24. And R is Waiver of Notice of Hearing top. And did you receive notice of parole violation report, and the other documents I marked, and did you review them?
Yes.
Okay. Do you need to continue this hearing to obtain any additional evidence?
No, we do not.
Okay. We have no witnesses today, so it is now the defense's opportunity. Would you like to speak at this time?
I have nothing to add.
All right, so what I'm going to do next is I'm going to announce my findings. So on charge 1, Obeo laws, drugs, I do make a finding of probable cause based on evidence presented in support of the violation. This is on part 1, which is exhibited by Q and P, part 2, which is exhibited by M, N, and O, and part 4, which is exhibited by H and I. I make a no finding on part 3 due to there being insufficient evidence to support the charge. And on charge 2, condition no consumption of alcoholic beverages, I make a no finding of probable cause based on there being insufficient evidence. I do find the acts are serious enough to warrant revocation. This is also takes into account two misconducts received, as well as 2 overdoses, which resulted in a hospitalization. So DOC recommended you from diversion from the revocation process for substance abuse programming and treatment. This means if you want to participate, apply, and I find that you meet the criteria, I can continue your case while you provide an opportunity to participate in the substance abuse programming and treatment in the correctional facility. If you successfully complete the programming and treatment provided, I will dismiss your case and order your parole reinstated. If you do not complete the programming and treatment provided, the board will schedule and convene a revocation hearing to determine if you violated the conditions of your parole. If so, the hearing examiner would make recommendations regarding whether your parole should be revoked, what sanctions should be imposed. The decision to participate in diversion is voluntary. Do you understand the diversion process, and do you want to apply for it?
I actually already am. I started the top program October 2nd.
Okay, so that's great. So I have to put you in it in order for you to remain there. So that's why we're having a hearing today. So that's great that you started it. So I'm going to announce my findings with respect to your eligibility. If I determine you're eligible, I can accept your application and divert you from revocation. So I have reviewed all the relevant information, and my finding is as follows. I find you have no pending misdemeanor or felony charges. I find your discharge date is more than 60 business days from the date of today, from the date of your remand to custody. I find there is evidence you have identified substance abuse treatment needs. I find that substance abuse is reasonably considered to be a motivating factor in your alleged failure to comply with the terms and conditions of parole. And I find there's some evidence that you have received or provided with an opportunity to receive substance abuse programming or treatment during your period of parole supervision in the community. I have determined you are eligible for diversion for substance abuse programming and treatment. Before I accept your application for diversion, I ask you to indicate whether you understand the following by saying yes or no. I understand I will remain incarcerated while I receive programming and treatment, and that parole revocation proceedings may be delayed as a result.
Yes.
I understand that dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon my successful completion of the TOP program.
Yes.
I understand that ultimately DOC will determine whether I have successfully completed the treatment provided.
Yes.
I understand that my participation in this process is completely voluntary.
Yes.
All right, so your application for diversion is granted, and you already started the program. You have 60 business days to complete the program. Do you have any questions?
No.
Okay, so I wish you the best of luck. Hope you do well. Make sure you don't get tickets or anything, or else you're going to be taken from the program. Okay, so I hope it benefits you and you get something out of it before you come back out. Okay.
Thank you.
All right.
Good luck, miss.
You're all set.
Thank you.
Thank you. Thank you, Hearing Examiner Meisinger.
Thank you. Have a good day.
You too.
Okay. We have a attorney, Turley.
Hi, Hearing Meisinger. How are you? I'm present.
Good. How are you?
Good, thank you. We're here for Derrell Soulds today.
Yes.
So we have a bunch of letters and stuff. It's kind of we kind of did the groundwork. Would you like me to submit them to you via email as exhibits, or is there a better way, for me to read them to the record? What would be sort of best for you? I know last time we sent you in we sent you an email, I think, or actually rather we sent Ruth an email, I think, with the exhibits.
I would, if you would like to include them, I need them sent now to me. If you want them prior to me making a recommendation, I would send it now.
All right.
So I can review that before I make a recommendation.
Okay. And do you have the, should I resend the letters we had last time, or do you want?
No, you do not need to resend anything that I already have. I'm going to connect to him now. So.
All right.
How many exhibits are there?
There's about, I think there's about 5. We have his sentence mod packet too, but I guess that would technically be 6.
Right, you can, and just so you know, next time if you can submit this all in advance as soon as you get it.
Okay.
So that I can review it, prior to the hearing.
All right.
That way it's a little faster.
And we have reentry resources, but it's just generally it's just from my social worker.
If it's something smaller too, you can just go over it in that time of the hearing if you like. Good morning, Soulds.
Good morning.
Good morning.
How are you?
Good, thanks. We're here for your revocation hearing today, and I have your attorney here.
Hey, Derrell.
Good morning, Blake.
They got you in the soundproof room, looks like.
Yeah, I guess you could say that.
Okay. So, Attorney Turley, are you all set to begin?
I believe so. Did you receive that email?
Not yet.
All right. I can begin though in the interim.
And you can also, if there's anything that you'd like to discuss in regards to those attachments, you can give like a brief summary of whatever is said as well.
Okay. All right.
So we're going to begin. So, good morning. I am P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This revocation hearing concerning Soulds Derrell number 226100. Today is October 8th, 2024. This hearing is being conducted via video at the BOPP Central Office in Cheshire Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Please state for me your full name and DOC inmate number for the record, sir.
Derrell Michael Soulds, 226100.
You have counsel here today. Please identify yourself for the record.
Hi, Attorney Blake Turley.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better weighted evidence must establish that, more probably than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation or one or more conditions of your parole, I'll reinstate your parole, release you, place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, A supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge, state your PO is bringing against you. I will review identifying exhibits filed for the record. Counsel will then have an opportunity to present all relevant testimony in any relevant documents. After considering all the evidence presented, I will announce my findings. If I find you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, I do not.
Okay. So your important rights today, you have the right to have an attorney present and you have counsel here. You received the written notice that charges the violation. Did you receive that written notice?
I did.
Okay. You have a right to view the evidence against you before the hearing. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights? And are you ready to move forward?
I am, and I do.
Okay. So we will now review the charge the state your PO is bringing against you and the information underlying each charge. And I will note the addendum from PCS reported on 8/12/2024. You were granted the DICSP program for that charge of possession of controlled substance first offense. Therefore, charge 2, PCS did request to withdraw the warrant in regards to that charge. So charge 2 will not be taken into consideration today. So charge 1 under release direction program participation states by your officer on 6/5/24, you were discharged unsuccessfully from CBT at Waterbury CPA AIC due to your negative attitude. On 6/3/24, you exhibited disruptive behaviors in group, making groaning noises, phones, and other erratic behavior. You accused the facilitator of treating you like a slave because you were asked to participate, which you then threw a fit about the facilitator threatening him because she stated that you will be asked to leave. You didn't participate. After explaining that it is important that you participated, you asked the facilitator to take the knife out of his back when asked to participate in another instance. You also approached staff as she was heading to her office and stated that because the facilitator was asking you to participate, you feel like a monkey. After making that comment, you were taken to the program manager's office where you then stated again that you must report to group, which takes away from your employment opportunities, and you hate going to the group, so you will not participate and continue to give short answers. As you were leaving the meeting, you made an inappropriate random comment towards the program manager stating that you heard she was at a Bryson Tiller concert twerking. You were deemed to not be an appropriate fit for group and were discharged. As a result, you were no longer permitted at Community Partners in Action. You were not recommended for another group as it would not fit your need due to you making the group a hostile environment and the facilitator uncomfortable. Based on your actions, you violated conditions of parole, specifically release directions. I will be assigned to one of the several levels of community supervision and agree to participate in programs as deemed by my parole officer. Charge 3, under additional conditions, halfway house placement. Your charging officer reported on, this was separated into 5 parts. So it states on 3/8/24 at 2:47 p.m. you were issued a community pass from the Chase Center to the DMV. You contacted the halfway house staff, made a false statement as to why you were going to be late. You informed staff that someone was acting crazy in the DMV and that they had a gun. You said they made everyone leave the building. Chase staff told you she would call you back. You stated that you did not have a phone and that you borrowed one from some random girl. Staff stated she had the same name as you. The call ID showed Armani Soulds and the number. What are the odds? Staff called the number to give you a new ETA and was informed that you were already on your way to the facility. You returned late to the halfway house at 3:33 p.m. was dropped off by your aunt, an unapproved driver. After returning to the halfway house, you admitted you went to your mother's house without permission from the halfway house or parole. Based on your actions, you violated halfway house agreement. Specifically, I will only go to locations indicated on an approved community pass unless changes have been authorized by staff. On 5/13/24, staff entered your room looking for offender Hathaway who was not assigned to your room. When staff knocked on the bathroom door, you stated you were in there alone. Once you left the room, staff went back in the room and Hathaway was standing in front of the bathroom. You were past search, you were found to have a lighter contraband on you. Based on your actions, you violated halfway house rule violations, Class C contraband, any item not specifically approved by staff for your possession in Class D line staff. On 7/10/24 at 1:27 p.m. a room search was conducted in your assigned room at Chase Center halfway house. During the room search, staff found an Axe, aerosol, body spray, and pack of razor blades in your belongings. You violated halfway house rules, Class C rule violations, specifically any item not specifically approved by staff. On 7/15/24, you were scheduled to work from 8:30 a.m. to 5:30 p.m. You signed out of the Chase halfway house for work at 6:55 a.m. with a return time of 10 p.m. You returned to the program at 6:18 p.m. On 7/16/24, you were scheduled to work from 8:30 p.m. till 5:30 p.m. with return time at 7:45 p.m. at Apex Elect and Marketing located at 2440 Whitney Ave in Hamden. You signed out of the program at 7:17 a.m. to go to work. At approximately 4 p.m., Chase staff saw you on Main Street in Waterbury. She sent pictures of you and a female walking into a store. Staff called Apex and spoke to Supervisor Freddie, who stated that you were told on 7/15/24 that they could not hire you due to your criminal background. He reported that you left their location at 3 p.m. on 7/15/24 and knew not to return on 7/16/24. Staff called you on your cell at approximately 4:15 p.m. and inquired about work, which you stated was going good. Staff asked you for a second time, how was work? And you replied, oh, I'm not at work. I'm at the Ford Clinic, and I told CMS John I was going there this morning. Staff asked what time you were scheduled to return from your past, and you stated 7 p.m. Staff informed you that you were spotted on Main Street in Waterbury and gave you direct orders to return to the halfway house in 20 minutes. You returned to the program at 4:45 p.m. and you were unaccounted for on 7/15/24 from 3 p.m. to 6:18 p.m. and 7/16/24 from 7:17 a.m. until 4:45 p.m. A total of 12 hours and 46 minutes. You violated half house agreement specifically. I only go to locations indicated on approved community pass unless changes have been authorized by staff. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, remand to actual custody, B, parole violation report, C, PCS signed conditions, D, half house agreement, E, community solutions disciplinary action reports, F, residential discipline reports, G, community solutions incident report, H, CT, DOC, PCS incident report, I, offender misconducts, J, CT Department of Public Safety investigation report ending in 8986, K, CT judicial pending case detail, L, 2 pictures of cocaine, M, 2 pictures of Soulds walking out of the halfway house in 7/22 report wearing black sneakers, N, email from CPA's Cassandra Ford discharging Soulds from CBT. O, Community Partners Action AIC progress report dated 6/10/24. P, CSI client handbook page 23. Q, client handbook sign off form. R, notice of parolee rights, and S is notice of parole violation. Did you receive notice of parole violation report, and those other items I marked, and did you review them?
I did, and I did.
Thank you. And we have no witnesses today. It is now defense's opportunity if you'd like to speak to any of the evidence at this time regarding the charges.
Yes, thank you. And I would also like to reserve a moment just to speak about Derrell and his background and also kind of our plan we have set up for him. So charge 1 addresses the program participation. We understand that this involves his discharge from the cognitive behavior therapy at Waterbury CPA AIC due to perceived disruptive behavior. While the report does list specific incidents, I ask you to consider the broader context of Derrell's frustration and the amount of pressure he was at the time. It's important that he was not resisting rehabilitation. He was trying to balance mandatory participation in the program with his job obligations. Employment is not just a condition of parole, it's a critical part of the successful reentry into society. The conflict between his work schedule and his CBT program created an enormous amount of stress for Derrell. His negative reactions, while not ideal, were the result of his deep desire to secure stable employment and lay the groundwork for a better future. Derrell's frustrations from feeling like the program was putting his employment at risk, a situation he feared could derail the progress he already made, was yes, his comments were inappropriate, but they were born from this conflict between the program requirements and his need to provide for himself. The key point here is that Derrell is not rejecting treatment or rehabilitation. He was struggling to manage competing responsibilities. But what's more is Derrell's reflected on these incidents and recognizes that he could have handled them differently. He deeply regrets how his frustrations manifested, and he has expressed a strong commitment to engaging productively in future rehabilitative programs. This is not someone who is defiant or unwilling to improve. This is someone who made a mistake in the heat of a moment and has since taken full accountability for his actions. In fact, Derrell has completed other programs, other critical programs, such as Voices, anger management, demonstrating that he can and does engage positively in rehabilitative efforts. And this is in his motion exhibit I sent to you for his motion for sentence mod. These achievements, along with his ongoing pursuit of a human services certification, show that Derrell is on a path for personal growth and transformation. That's also a cert that's in his motion for a sentence mod. His progress should not be discounted because of one difficult moment in CBT. In light of these factors, it's clear that this is a single incident. It doesn't define Derrell overall. It doesn't define his commitment to rehabilitation. And I urge you to review this as an event, as an anomaly, not a pattern, and to focus on the strides he made towards being a responsible, law-abiding citizen. Secondly, or rather, charge 3 related to the halfway house placement violations. Charge 3 outlines several instances where Derrell deviated or allegedly deviated from approved community pass locations, returned late, or was unaccounted for during certain hours. While these are technical violations, it's essential to consider Derrell's intent and the mitigating factors at play. One key incident involved Derrell lying about a situation at the DMV to cover the fact that he visited his mother. He has admitted to this and is deeply remorseful. Let me be clear, Derrell's actions were wrong, but they were driven by concern for his mother's health, not a willful desire to disregard parole conditions. This was a moment of poor judgment motivated by a genuine concern for his family. And since then, Derrell has expressed regret and a commitment to being fully transparent in the future. Another violation stems from Derrell attending the Ford Clinic without proper authorization. The reason here is for being there are entirely legitimate. He was receiving treatment, which is a key part of the rehabilitation plan. However, due to miscommunication and logistical challenges, he failed to properly update his pass location. It's important to note that during this time, Derrell was not engaging in any illegal or harmful behavior. He was attending his treatment program and trying to balance his various obligations. The report also mentions minor contraband violations, such as possessions of a lighter and personal grooming items. And these infractions, while technically violations of halfway house rules, don't indicate any intent to harm or deceive. Rather, they highlight the rigid nature of the rules and the challenges faced by individuals like Derrell who are adjusting to life outside of prison. What stands out most is Derrell's overall behavior during these incidents. While there were lapses in judgment, none of those actions were malicious or indicative of a person who was not trying to comply. He was doing his best to manage his treatment, his work, and his personal responsibilities, all while trying to navigate the complexities of parole conditions. His violations are reflective of logistical missteps and moments of poor decision-making, not defiance or lack of commitment to his reentry. We're here today not to judge Derrell solely on these isolated incidents, but to evaluate his overall progress and potential for successful reintegration. Derrell is not somebody resisting change. He's made real strides in his rehabilitation, evidenced by his certificates, his participation in multiple programs, his willingness to take responsibilities for his actions. And I'll stop there.
I will give you another chance to speak too before I make a recommendation. I appreciate your statements regarding the charges. So I'm going to be right with you with my findings. And I do want to know, I have received the evidence that you have submitted to me. I do have five attachments, which include treatment letters, letters from William Outlaw, motion for sentence modification, reentry resources New Haven, as well as a letter from Prosperity House. So I did receive these documents, and I have reviewed these documents, and I will be submitting them as evidence into our system as well after.
And what's made us add sort of what's not there is, and it's kind of been tricky because he's been incarcerated. Is we've applied and got job offers for like place in Hampton, a deli, dishwashing. So he's all set up for that stuff.
Okay.
We've sent the applications, so he's ready.
All right, so what I'm going to do is I'm just going to announce my findings with respect to the charges. So on that charge 1, I do make a finding that you violated condition program participation based on the evidence that was provided in support of that charge, exhibits I, N, and O. As I previously stated, charge 2 is not taken into consideration as the charge was, this was withdrawn by PCS, the warrant for that, so that you may participate in the DICSP program. On charge 3, I do find you violated condition, official board condition, halfway house placement. This is based on the evidence that was provided in support of that charge, which is exhibit D, E, P, Q, G, I, F, H, and K. So that includes the fact-finding portion of the hearing. Before I make a recommendation, counsel will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So I'm not sure if you have anything else you'd like to say prior to me making my recommendation at this time.
I do. Derrell, would you like to speak as well?
Yes, please, if I may.
If you do want to speak, I just need to swear you in under oath first. Can you please raise your right hand? You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give in this case shall be the truth, the whole truth, and nothing but the truth to help you God upon penalty of perjury?
I do.
All right, go ahead.
Just quickly, as far as the infractions go, it's like my attorney said, I take full responsibility for the fact that, I wasn't handling things the best way I could have, you know what I mean? When you're locked up, you envision your life going a certain way. And then when I come home, I find myself in some rough waters. And, I was frustrated and I wasn't handling it properly. And, me being here for, this amount of time has given me a chance to really look back and reflect on the way that things was happening. And, like I said, I take full responsibility for those things. I also had the opportunity to look over the handbook from the community solutions that they submitted along with my violation papers. And I've taken all the rules to memory. And I assure you that, we're not going to have these problems anymore. I'm too old for this. The in and out, the revocation hearings and such, like Miss Meisinger, I'm done with this. You know what I mean? Really. And, whatever you find or whatever you choose to find, I would just ask that you consider that myself and my support system, we've taken some great strides to set me up to be successful immediately. Like my attorney said, I have 2 job prongs, one at Splash Auto and one at this deli out in Hamden in the New Haven area. The Prosperity House is willing to give me a bed. I would like to be able to be re-paroled to the halfway house and then make a transition to Prosperity House, because at this program and Prosperity, they allow me to reside there 3 months rent free. So all the money that I would be making from these employment opportunities, I could save for self-sponsor. So I would just ask that you consider that, Miss. I'm proactively, taking strides towards my freedom. Like I said, man, those situations that happen in the halfway house, they won't repeat themselves again. I actually feel kind of ashamed having gotten caught up in all that when I should have just stayed focused on the task at hand, which was full-time employment.
And so you want to go to a halfway house in New Haven?
Yes, please.
Okay.
Because all of my endeavors, everything around me, the first program at the Ford Clinic, the job opportunities, everything, like even my niece, she just got accepted into UNH. She's out there by herself, So, the New Haven is definitely.
Derrell, can I just jump in? I think, just to reiterate, he has, there's a bed at the Prosperity House for him. It's available October 14th. We have a deposit. We have money for him to put the deposit down. My understanding of how it works is he goes to the halfway house for, it's easier to have him released to Prosperity from there. If you wanted to work with him, I think if you guys could work with him to get him into the Prosperity House directly, that would also be an option. But we've gone, pretty far getting him, situated so he wouldn't be necessarily, returning to, the halfway house. He would be down in New Haven at Prosperity, which is what Derrell had intended.
Damn, what's up with them glasses?
We also have, yes. So thank you. And that was also a letter from the Prosperity House. They have certain criteria. Derrell is eligible. So if I may, I'd like to add to that. Derrell is kind of echo, more or less what you were saying with the plan, but also kind of cover the background, if I may have a minute or several.
Go ahead.
Thanks. So, again, good afternoon, as it is. So Derrell's seeking a opportunity to continue on the path of rehabilitation and reintegration. He has grown, he has matured, and he has taken time to reflect and develop the tools necessary to reintegrate successfully and contribute to the community. And so I'm going to explain in the next couple of minutes sort of the path that he is ready to continue if he is given the chance. First, Derrell's personal background. He grew up in a challenging environment, raised by a single parent in a lower middle class neighborhood where gang violence was prevalent. Despite these early obstacles, Derrell has always had a strong support system with his family, and particularly his mother. She provided unwavering support during his incarceration, and he's still close to her today. He's taking full advantage of the opportunities available to him in prison and on parole to make use of the programs available and to help him transition back into society. During this time, he attended Middletown Community College. He gained valuable skills in administration, marketing, custodial work, and community outreach. While incarcerated, he engaged in commercial cleaning work, further gaining experience that will aid him back again in transition back into society. Derrell has often reflected on his time incarceration and how it's changed him. He said something to me that was pretty important and profound. He said, "Life is all about time and what you do with it." And he understands now the importance of making the most of the time he has left. He lost people he cared about during his time in prison, which fundamentally shifted his perspective. This reflection has fueled his determination to live a life that's productive and meaningful and in service to others. Now addresses rehabilitation and self-improvement. And since his initial incarceration, Derrell has taken significant steps to improve himself. He has participated in countless programs. He is a part of the Million Jobs campaign, the Wheeler Foundation, the Welcome Center in Waterbury, and the Ford Clinic. These are rehabilitative programs, and they've given him a different trajectory, one focused on counseling, recovery, and giving back to the community. He now understands that his calling is to help others through counseling and recovery coaching, and he is committed to pursuing his path. Derrell has learned how to handle stress and conflict much better than when he was first incarcerated. He now implements positive coping mechanisms such as exercise and mindfulness, which have greatly improved his ability to remain calm and focused, even in difficult situations. He's also built a network of mentors and positive influences, including Marcus Cherry, Mike Murley, and Kanji Cooper, who have guided him and provided him with opportunities for personal growth. We've also taken concrete plans to further assist his reintegration. And his release is essential for his continued rehabilitation and reintegration into society. We have a concrete, actionable plan in place to ensure his success. Upon release, Derrell will be transferred back to the halfway house, and then, upon availability of a bed, live at the Prosperity House. He has already been deemed eligible for the program. Prosperity has generously agreed to provide him with 3 months of rent-free housing, allowing him to save every penny from his job at Splash Car Wash for the deli. In addition to his job at Splash, Derrell is also an offer waiting for him at a gourmet deli in Hamden. These positions will give him the financial stability he needs to get back on his feet and eventually sponsor his own housing. Project Longevity has also committed to matching up to $3,000 to help Derrell secure an apartment, ensuring that he has a stable living situation once he transitions out of Prosperity. But his plans go beyond earning a simple living. Derrell is deeply committed to continuing his education at community college and completing his degree. He's also expressed a strong desire to give back to the community, particularly by working with organizations like Ford, F-O-R-D-D, to help others break the cycle of incarceration. He is determined to spread the message of hope, awareness, and change, helping to keep people from going down the same path he once traveled. Derrell has a clear understanding of why the violation occurred. It was a mistake, one that has reflected on him, and he's also reflected on, and he's learned from it. He is committed to moving forward differently, taking stock of all the rules and regulations, and complying fully with the terms of his parole. He understands that success can only come through hard work, dedication, and a commitment to doing things the right way. He's also not alone on his journey. Derrell has a strong support system and a clear path forward. He has a strong support system that includes his family, mentors I mentioned above, and community organizations. The Ford Clinic and his mentor, William Outlaw, are ready to continue working with him to ensure he remains on the right path. He will also continue to practice meditation, breathing exercises, and other mindfulness techniques to stay focused and calm in stressful situations. We are prepared to move forward with these plans today. Everything is in place for Derrell's release, and there is no need for any further delay. He has a bed at Prosperity. He has jobs waiting for him and the support of community organizations that are committed to his success. Derrell is ready to take full responsibilities for his life, continue his education, work, and give back to the community that has supported him. Derrell has demonstrated actions to demonstrate who he is through his actions. He's committed to rehabilitation. He's detailed plans for the future. And he's ready for another chance. He understands that there is no success in the illegal lifestyle, and he's committed to living a good, honest life, free from his past. We are respectfully asking the board to consider Derrell's growth, his commitment to a better future, and the extensive plans in place to ensure his success. Thank you. And I would also like to just hammer out I have a few more plans for reintegration. The first is that this plan is comprehensive, actionable, and it's supported by numerous organizations and resources. This includes the Prosperity House. So that's in reference to the Derrell Letter 1. They've offered, and which is not on there, is they have a 3-month rent-free program. They also offer free rent as long as you're in school or you're working full-time. This is going to allow Derrell to save his earnings from Splash. He is also going to benefit from the stable living situation in his transition to incarceration by remaining in constant contact with these organizations to ensure that these arrangements stay in place. Prosperity House is ready to support him the moment he gets out of prison. Exhibit 2 are the employment opportunities. Splash has offered Derrell a position. There's Deli and Hamden that has extended employment offer. He's also got a number of reentry resources that are available and that we are ready to mobilize. His job at Splash allowed him to save his earnings, and Project Longevity has committed to matching $3,000 to help him secure placement in the more permanent housing in New Haven. He has the financial stability, employment, and savings plan necessary for successful reintegration into society. So Exhibit 3 is his continued treatment and support. There's letters from Dan Varley at the Forensic Drug Diversionary Clinic, or the Ford Clinic, as we've been calling it, which is a joint program with the Connecticut Mental Health Center and Yale School of Medicine, or Yale School of Medicine. They have already seen and treated Derrell with individual sessions focused on relapse, prevention, and mental health management, and they are prepared to continue working with him upon his release. Additionally, William Outlaw from the Connecticut Violence Intervention Program, CTVIP, has expressed his commitment to working closely with Derrell. And that's the William Outlaw letter. This program is designed to further prevent involvement in the criminal justice system. And with William's guidance, Derrell will have strong mentorship and risk management strategies to ensure he remains on a positive path. Exhibit 4, this is just generally the reentry resources and network. There's programs, just Fresh Start, Project More, and other housing and employment services that are ready to assist him as he transitions back into the community. That's the reentry resources letter. These programs specialize in helping individuals like Derrell maintain a stable and productive life post-incarceration. He will have access to job placement services, housing options, and continued mental health care, giving him every tool necessary to succeed. And I'd also like to point out Exhibit 5, which speaks to his educational achievements and certificates. One of the most commendable aspects of Derrell's time in incarceration was his relentless pursuit of education and personal development. As detailed in the certificates attached to his motion for sentence modification, Derrell has completed a multitude of rehabilitative programs and educational courses that have not only helped him grow as a person, but have also provided him with valuable skills that will serve him well upon his release. And those are in a motion for sentence modification. He's only 6 credits away from completing his human services certificate through Aston Untuck Community College. That's also in the most sentence mod. This certificate is a crucial step towards his long-term goal of becoming a recovery coach or life coach, using his own experiences to guide and support others through difficult times. In addition, Derrell's earned certificates in numerous rehabilitative programs. And let me point a few out. The Voices program, which is the Victim Offender Institutional Corrective Education Services, which helped him deeply understand the impact of crime on victims, families, and communities. That's in the Derrell Soulds motion for sentence modification packet. Good Intentions, Bad Choices, which emphasize decision-making and accountability. Also in the Derrell Soulds motion for sentence mod. Anger management, alternatives to violence, and Tier 2 substance abuse programs, all of which have provided him with tools necessary to manage stress, conflict, and relapse triggers in a healthy and constructive way. Those are also in Derrell Soulds' motion for sentence modification. During his incarceration, Derrell has constantly demonstrated good behavior. As Judge INMATE noted through a sentence modification hearing, quote, "He seems to have been a good prisoner. I can't find anything negative that has occurred by him in jail during that 6-year period. He seems to have taken advantage of most, if not all, of the resources available to him in jail." That's Derrell Soulds' motion for sentence modification. These words.
Hey, excuse me. I think they're I think they're kicking me out back here. The CO keeps giving me this look. I don't know what's going on. I just don't want to get into trouble.
Well, we're gonna finish the hearing. If he comes in and talks, then I'll address it.
All right. Okay.
Do you have anything else?
Yes. So Judge INMATE's words highlight Derrell's dedication to growth, commitment to rehabilitation, and his readiness to apply these lessons in the outside world. Then the last exhibit, this is just generally, his, as Derrell has mentioned, his long-term goals to become a recovery life coach, helping others navigate the same challenges he has faced. He plans to continue his education, finish his certification, and use his life as an example to mentor those who are at risk of making the same mistakes he once did. And it's not just a goal, it's a calling. He's shown his ability to mentor and lead others within the prison system. He's earned the respect of both the inmates and DOC staff alike. He's has a great ability to foster meaningful relationships. He provides guidance to others, inspires others who have been recognized by figures like Imam Usman, who once said that his ability to work with people achieving a common goal is one that is greatly needed in the wider community. And that's in Derrell's motion for a sentence modification. Derrell is ready to step into this role, not only for his own sake, but for the betterment of the community. With the support of organizations like Ford and the CTVIP, he will be able to continue this important work immediately upon his release. So, we have here a man who's taken responsibility, and he has done everything in his power to rehabilitate. He's now prepared to reintegrate into society as a contributing, law-abiding citizen. This structured plan we presented today is thorough and realistic, and it's supported by many community organizations and professionals. Derrell's educational achievements, his work opportunities, his housing stability, and his continued treatment programs ensure that he will return to society successfully. Derrell has demonstrated through his actions, his achievements, and his unwavering commitment to self-empowerment that he's ready for this next step. He has the tools, he has the support, and the determination to build a better life, not just for himself, but for others. His release is not just a second chance, it's an opportunity to continue a journey of redemption and transformation. Thus, we respectfully ask this board to consider the substantial progress Derrell has made, the opportunities that await him, the positive impact he has on his community. And thank you for your time and consideration.
Thank you very much. I appreciate it. So as I previously stated, I did review all the evidence. I've listened to all the testimony today. I have reviewed all the evidence provided by the state. I will note on the record, there are no prior violations on this period of special parole supervision. There are 5 misconducts that the offender did receive, and he was in the community for about 4.5 months before returning to custody. He is incarcerated, he is on special parole for 5 counts of robbery first with a 12-year special parole term to serve, which is what you are on right now. So based on all the information that I have received today and reviewed, I am going to make a recommendation that parole be revoked, to be re-paroled for October 28th, 2024. This is about a 3-month period of confinement as a sanction. I'm going to recommend the following parole conditions: halfway house placement, noted New Haven, no consumption of alcoholic beverages, mental health evaluation and treatment as deemed necessary, no contact with victims, Subway, 34 Thomas Ave, Waterbury, Family Dollar, 91 Cook Street, Waterbury, Webster Bank, 80 Elm Street, New Haven, Walgreens, 1191 Dixwell Ave, Hamden, Ion Bank, 367 East Main Street in Waterbury, Connecticut. My findings are going to go to the parole board on October 17th. So October 17th, I present this to the parole board. They can agree with me and release you on October 28th. If they do agree with me, you would be released that day because you are on special parole, so you would be released. If not, they can also make that longer if they would like, or as soon as 10/17 would be the soonest. Do you have any questions? Do you understand?
How likely are either one of those?
I'm not the parole board, so I mean, you got a lot of positive things going on. I mean, it's up to the board though, on that decision, but,
okay.
So you'll get it in writing about a week after 10/17. So if you're still there, then you might be leaving. You'll get that notification of what your conditions are and what the date was the board picked, mailed to you. So you will get that. And I wish you the best of luck, sir. You got a lot of positive things going for you. So I hope that you can do all those wonderful things that I just heard about.
Miss Messenger.
Yes.
You're not going to see me again.
I hope not, unless it's doing something good and you're on TV and I hear about how awesome you are. That's the only way I'd want to see you. So
no, I want to advocate for guys like me.
I hear you, and I hope you're out there and you do good because there's a lot needed out there. So I wish you the best of luck, sir.
Thank you.
If the circumstances change, so he'll have a bed October 14th. If we put the package together, can we send in the Prosperity House application? Because it may be the case he could just get released directly to Prosperity House.
That's going to be up to the officer. I'm going to put the information in there for the officer regarding the Prosperity House, so they have it. It's up to the officer where he is placed, though. But I will put that with his information.
Is he going to have Lisa Grant again for his PO officer? You know?
I'm not sure who he's going to be assigned to. I'm not sure who's in that district.
All right.
You put New Haven, though, correct?
Yes. Yes.
Thank you.
Yes.
Thank you, Miss Messenger. You have a great day, okay?
Good luck. You're all set.
All right.
All right. Thank you so
Blake,
much. Yes.
We'll see you, Blake.
Right,
I'll
Derrell.
be in touch.
I'll talk to you today. Bye.
Yep.
Thank you, Attorney Turley.
Thank you. Bye.
Have a good day.
You too. Have a good day.
All right. How do you guys feel about that guy? I think out of everybody, he's probably one of the better ones that I would grant out parole to. And my apologies, for running around. I do have 4 streams running. Right now we currently got this one, which would be Connecticut. We also got Utah. What else do we have? We got Pennsylvania, and I just added Iowa. So I just had to make sure everything was up and running and there was no issues and whatnot. So right now I'll go ahead and stick around.
Good morning. Sorry, we're running behind today.
Yeah, you are.
Is Sanchez there?
Sanchez is here, correct.
Can I see Sanchez and then Rodriguez and then White?
Sanchez.
And then Anthony last.
So Sanchez, Rodriguez, and then White.
Okay. So we still got a few.
Okay.
So we got about
Sanchez.
4. All right, I'm
What do you
going
have for-
to put up their info up on the screen, and I'm going to look them up and see what kind of cases they got. And it's Starlight, if you're still in here, hey, thank you for tapping in. I saw your comment a bit ago. Then also Casey _ Tiffany, highly appreciate it. Let me see what else. That's all I see on the comments right now as far as the TT side. If you're on the other streaming platform, hey, welcome Summer. Let me see Kara. Let me see who else right here. We got Moon, Crystal VR.
Good morning,
Chrissy
sir.
G.
Mr. Sanchez?
Good morning.
Good morning. We're here today for your revocation hearing, yes.
Sanchez. Let's see what's up with Sanchez over here. I'm gonna look him up
All
right now
right,
on
so
Google.
we are going to start it in 1 minute.
All right, plenty of time. Sedrick, spelled with an S. Let me see, Sedrick. Oh, I found him right here. Let me see. Violation of standing criminal protective order, second degree, threatening reckless violence. What the what? Hey, man, Sanchez is off the chain right here. KK, Grand Rising. Hey, welcome.
Phil McNeil. We have Mr. Sanchez here. We're going to start his hearing.
Yes.
Okay.
Okay, let me put up Mr. Sanchez
Good
over
morning,
here for
I'm
you
Phil
guys.
Meisinger, hearing examiner for the Board of Pardons and Paroles. Revocation hearing concerning Sanchez Sedrick, number 421462. Today is October 8th, 2024. This hearing is being conducted via video at the BOPP Central Office of Carl Robinson Correctional Institution. This is a public hearing. Public access hearing is available via video live stream. Can you please state for me your full name and DOC inmate number for the record, sir?
Oh, no.
Cedric Sanchez, 421462, 113078.
Thank you. And you have parole officer present. You please identify yourself for the record.
Mr.
McNeil.
She's here. And then I have counsel here today. Please identify yourself for the record.
Attorney Alfonzo Sirica, public defender with the Parole Revocation Unit.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, just release you, place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge. The state, your parole officer is bringing against you. I will review and identify exhibits filed for the record. The state will then have the opportunity to present relevant testimony. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure?
No.
You have important rights at today's hearing. You have the right to have an attorney present. You have counsel here. You have the right to receive the written notice to charge of the violation. Did you receive the written notice?
Yes, ma'am.
You have a right to view the evidence against you. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to move forward?
Yes.
So we now review the charge the state your officer is bringing against you and the information underlying each charge. So P.O. McNeil, if you please read the charges.
Yes, how are you, Sanchez?
He's not going to hear you. Go ahead.
Charge 1, obedience to the law. On 2/8/24, 2/10/24, 2/11/24, you showed up to your victim, Christy Escobar's place of employment at AutoZone on 564 West Main Street, Waterbury, Connecticut. On 2/11/24, you approached the victim as she was leaving her place of employment and made verbal threats stating, "You're lucky Buzo is not here, and I will take out your family one by one." On 2/27/24, a warrant for your arrest was issued for 3 counts of violating standing criminal protective order 53A-223A and threatening reckless violence in the second 53A-62A-2B. On 3/12/24, you were arrested upon your discharge from St. Mary's Hospital by Waterbury Police and arraigned on 3/13/24 at GA4 Waterbury Court. Charge 2, no contact with victims. Your special parole conditions state throughout your period of parole, you are to have no contact with Christy Escobar, the victim of your offense, on 2/8/24, 2/10/24 and 2/11/24, you showed up to your victim, Christy Escobar's place of employment at AutoZone on 564 West Main Street, Waterbury, Connecticut. On 2/11/24, you approached the victim as she was leaving her place of employment and made verbal threats stating, "Your lucky bozo is not here, and I will take out your family one by one."
Damn.
You are in violation of your special parole conditions and standing protective order.
Thank you. And the state has filed the following exhibits remarked for identification purposes as Exhibit A, Raymond actual custody order, B, special parole conditions, C, notice of parole violation, D, notice of parole rights, E, parole violation report, F, Waterbury Police Department case incident report, G, State of Connecticut Superior Court arrest warrant application, H, it's collect protective order registry file 20. And did you receive the notice of parole violation report, and those other items I marked? And did you review them, sir?
Yes.
And counsel has filed the following exhibit pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence? We don't have any witnesses today. I'm going to swear you in, P.O. McNeil. I'm also going to swear in Mr. Sanchez in case you would like to speak today. Can you please raise your right hand?
Yes.
You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give in this case shall be the truth, the whole truth, and nothing but the truth to help you God upon penalty of perjury?
Yes.
Okay. So, P.O. McNeil, would you like to say anything at this time?
No, ma'am.
This is the parole officer.
Oh, okay. I can't hear.
Okay, I just want to know,
Excuse me, P.O. McNeil, can you hold on 1 second? Is there a way to turn up the volume so my client can hear a little better? He also has some hearing issues.
Not sure.
Hold on 1 second.
If you can't hear us, just raise your hand and let me know, and we're gonna talk louder, and I'm gonna repeat it for you, okay?
Okay. Meisinger, I do have one option if I can pop in for a moment.
Sure. All right, we're just gonna see if we can turn up a little bit.
Let's
I don't think that's needed. I think we just need to talk louder than.
Yeah.
Okay, so if, like I said, I'm gonna talk louder, so if you can't hear me, just raise your hand, let me know, okay? All right, so, P.O. McNeil, go ahead.
okay, I don't really have anything much to say. I'll just note that during Sedrick's time with me, I haven't had any issues with him. This has been his first blemish with me. He's been compliant throughout his time on parole as under my supervision. So yeah, that's all I have to say. This has been his first blemish.
All right, thank you. I appreciate that. So now I'm going to turn this over to counsel if you'd like to say anything.
I know you didn't put,
So yeah, I did receive an addendum from PCS. The addendum reported 9/4/2024. Offender was convicted of violation of a standing criminal protective order, received a 1-year jail sentence with all other charges nollied. The EOS date on this sentence is 3/9/25, with a TS eligibility of 9. Let me just check, make sure the updated one would be 9/8/24 is the updated PED date. So now I'm turning over to counsel.
Yes. Briefly regarding the first part of the hearing, that is the correct addendum. I did speak to my client. He was remanded on March 12th of 24. He did dispose of the case on September 4th of 2024. That's brief comments regarding the first part of the hearing. I want to be heard about his background at the appropriate time, please.
All right, so what I'm going to do next is I'm going to announce my findings. So on charge 1, I do find you violated conditional bail laws of being civil law. Based on your conviction of violation of a standing criminal protective order, receive a sentence of 1 year jail. On charge 2, I do find you violated condition, additional board condition, no contact with victim, based on the evidence that was provided in support of that charge, which is exhibits B, F, and H. So that includes the fact-finding portion of this hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. The purpose of this part of the hearing is to help determine what outcome I will recommend. So at this time, Peter McNeil, would you like to say anything at this time?
I have nothing to say.
Okay, so, counsel, anything you'd like to say at this
On
time?
behalf of Mr. Sanchez, I am respectfully requesting to have my client reinstated as soon as possible. As P.O. McNeil indicated, he beat me to it. I'm showing my client was paroled on January 7th of 2022. He was not remanded until March 12th of 24. If my math is correct here, it's a little bit over 2 years. As the parole officer indicated, there have been no issues with Mr. Sanchez while on his parole supervision. I don't see any misconduct. I don't see any previous violations. And he's been incarcerated since March 12th. My client is 45 years old. Upon his previous release, he did self-sponsor at an apartment in Waterbury. He's got some both mental health and medical issues. He was injured in 2010, which resulted in him being in a coma for 4 months. It looks like beginning of March of 2022, he did participate in treatment for the sexual behavior program. And he was also doing individual therapy in the community with the clinician Ariana. He does utilize Waterbury Hospital and when and if needed. As far as the reinstatement goes, as far as housing, I know he had indicated to me about going back to that Vine Street address. Apparently the parole officer, I believe, has been in contact with his wife, and that address is no longer feasible. So Sedrick, I know you gave us that address. The parole officer reached to your wife. Apparently that's not possible at this time. So you're gonna need to be placed in a halfway house to start and then work something out down the road. So what part of the state do you want to go? Because I don't have that information changed since the last time I talked to you. Where do you want to go? Waterbury. Okay, so I am asking to do that. He is interested in returning back to school after he takes care of his health issues. He wants to apply for disability for both mental health and medical purposes. And he's amenable to any treatment recommendation. Once again, he was out for over 2 years. There's no issues with him reporting no dirty urines I see here. I do understand there was a new charge, but he was out in the community for over 2 years. Thank you.
Thank you. So I'm going to be right with you with a recommendation.
All right. So how do you guys feel about this this hearing here? He hasn't had charges. He SO'd somebody. I think back in like 2017, I put up his case, but I couldn't really find out any information on it. And then they also mentioned it on the board of parole hearings. It's all bad all the way around. I mean, what else? What else can you say about it? Kind of scary, just thinking about all the people, all the other deviants that are out there that participate in those type of assaults.
So I have reviewed all the evidence. I have listened to testimony today. I see you were in the community for 2 years and 2 months. You did receive a new 1-year jail sentence for that violation of standing criminal protective order. You are on 5-year special parole for sex assault second.
Mm-hmm.
There are no prior violations or misconducts that I see.
Not good at all.
Based on the nature of the new conviction and the behavior of the violation of standing criminal protective order, I do recommend that parole be revoked, be re-paroled for March 9th of 2025, which is about a 1-year period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, preferably in Waterbury, no consumption of alcoholic beverages, mental health treatment and medication compliance, behavior management program for domestic violence, no contact with your victim, KE, no contact with minors and problem sexual behavior treatment. I will present this to the parole board on October 17th. So this is a recommendation. So the parole board has the ability, they can let you out sooner. They can let you out as soon as 10/17 if they would like. They can also hold you in longer if they would like. The board can revoke all of special parole if they deem necessary. So I am recommending your EUS stay on that new conviction. Do you have questions about anything? You will get everything in writing from the parole board, from us, about a week after 10/17. So you will know your conditions and what your re-parole date is, if they give you a re-parole date. Do you understand?
Yes.
Do you have questions about anything that I stated that you don't understand?
No.
Okay. So
Good luck, Sedrick.
So I wish you the best of luck, sir. You'll know a week after 10/17 what the board's decision is, okay?
All right.
All right, good luck, sir. Thank you, P.O. McNeil. You have, I'm gonna hear Rodriguez on right now as well.
Yes.
So we'll do that next.
Okay.
Yeah. Hey, one-way ticket to downstairs wouldn't be too bad. Let me see. So right now, I guess we're waiting for the next gentleman that's going to be coming in. Hopefully,
Yeah, I'm waiting.
Okay.
The next individual that's coming in is his name is going to be David White. I'm trying to look him up right now, trying to check what kind of history he has. Let me see here. I did find, but it's such a common name. I hate when people have common names because you can't decipher, if it is the individual or not until the board members start speaking. Oh, hold on.
We're just waiting for him to come on.
CT. All right, so I'm just I think this might have to do 7 arrests after counterfeit pill lab bust. Let me see. Let me check if his name is on this one. Huh. And this was last month. It's September 23rd. Let me check here the name. New Haven, Connecticut.
All right, Rodriguez.
Oh, Rodriguez. Oh, hold on.
Good morning, sir. Or good afternoon. So we're here today for your revocation hearing. So we are going to get started with that. Good morning. I am P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This revocation hearing, Attorney Rodriguez Lewis, number 277381. Today is October 8th, 2024. This hearing is being conducted via video at the BOPP Central Office in Carl Robinson Correctional Institution. This is a public hearing. Public access to the hearing is available via video live stream. Can you please state to me your full name and DOC inmate number for the record?
Los Rodriguez, inmate number 277381.
Thank you. And we have a parole officer present. And please identify yourself for the record. Thank you. And we have counsel here today. Please identify yourself.
Attorney Alfonzo, Sirica, Public Defender with the Parole Revocation Unit on behalf of Mr. Rodriguez.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, release you, and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we will review parole violation charges, state your PO is bringing against you. I will review and identify exhibits filed for the record. The state will have an opportunity to present a relevant testimony. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I will announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure?
No.
Okay. Important rights today: the right to have an attorney. You have counsel here today. You have right to receive the written notice charging the violation. Did you receive that written notice?
Yes.
You have a right to view the evidence against you. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to move forward?
Yes.
So now review the charge, the state your parole is bringing against you, and the information underlying each charge. So P.O. McNeil, if you could please read the charges.
Yes, charge 1 is GPS. On 5/13/24, you put off your GPS without PO permission. Your whereabouts in the community are unknown. This is a direct violation of the GPS monitor agreement that you signed and dated on 3/25/24. Charge 2, absconder. On 5/13/24, you were given an approved pass to attend your domestic violence group at 7:30 p.m. You were instructed and expected to return by 9:15 p.m. and failed to do so. At no time did you attempt to contact your PO nor halfway house staff. You intentionally dismissed the calls of halfway house staff and your PO. You cut off your GPS with no intention of returning back to Chase halfway house. Charge 3, halfway house placement. On 3/26/24, you signed the DOC client handbook when you arrived at Chase halfway house, acknowledging the rules and regulations of the program. On 5/8/24, you were asked to complete your 10:30 a.m. chore and refused. When staff told you that you were being issued a ticket, you replied, "Don't forget to sign it." This is a Class D rule violation of the DOC client handbook for failure to do assigned cleanup detail. That's it.
Thank you. In the state is filed the following exhibits pre-marked for identification purposes as Exhibit A, remand actual custody. B, special parole conditions. C, notice of parole violation. D, notice of parole rights. E, parole violation report. F, halfway house incident report. G, residential discipline report. H, GPS monitoring agreement. I, GPS violation report. And J is Community Solutions DOC handbook. Did you receive notice of parole violation report, and those other items I marked, and did you review them?
Yes, I did.
Okay, and counsel has filed the following exhibit pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence? No. We don't have any witnesses today. So at this time, the state is going to have an opportunity to testify with respect to the charges. I am going to swear in Phil McNeil. I'm also going to swear you in, sir, in the event that you do speak. Can you please raise your right hand? Do solemnly swear, sincerely affirm as the case may be, the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Correct.
Yes.
All right. So, P.O. McNeil, would you like to say anything at this time?
I just want to add that Rodriguez, he has a lengthy history of absconding. This makes his fourth.
Damn, fourth
he
one?
Also has.
He's a runner.
A history of violations, so that makes he's had 5 remands since 2020, 3 of those being absconders and 2 technical violations. When I met Mr. Rodriguez, he stated, he kind of mentioned how his thing is to abscond.
That's his thing.
He kind of makes threats that he has no problem leaving. So I spoke to his mother, and she questioned as to why he keeps getting released when he's constantly just absconding.
Mm-hmm.
That's all I have.
Okay. So I'm going to turn it over to counsel now, if you'd like to say anything regarding charges.
Yes. Mr. Rodriguez, the allegation here is you left supervision on May 13th of 2024, somewhere on or about August 4th of 2024, you self-surrender, correct, to the warrant?
Yeah, I turned myself in.
Okay. Could you just let the hearing examiner know kind of what was going on in your life on or about May 13th as why you left the facility?
I mean, I was trying to get treatment for my mental health, and I was off control. Like, I didn't really want to leave. I had a full-time job. I was cooperating with 3 groups. I was given a plea hearing for 3 months. I was in it. I mean, good DPS for 3 months. And I guess I was like, I tried to do the best this past time, but I know I didn't do what I was supposed to. But if I get a chance, I want to continue back with my groups and work. I had a good job at Restaurant Depot in East Main Street in Waterbury, Connecticut. And I want to just get back again and just do the right thing this time.
All right, we're going to talk about your background in the second part of the hearing. And I know your parole officer indicated you have obviously some history of leaving supervision, what's called an absconder. You didn't pick up any new charges while you were
No, I haven't picked up no new charges. I turned myself in to the Hartford PD and because of my mom. She was telling me to get this over with, and I did. And I want to get, I hope I don't get too much time.
All right. I'll talk about your history At the second part of the hearing, you already beat me to it regarding your jobs and the treatment and things of that nature. So I just wanted to put on the record kind of what was going on or about May 13th of 2024. My client did turn himself into the warrant August 4th of 2024.
Good job.
Thank you. So what I'm going to do next is I'm going to announce my findings. I do want to put on the record that on 6/7/24, the BOPP did issue an absconder warrant for the offender. So on charge 1, I do find you violated condition release section GPS based on the evidence provided exhibits H and I. On charge 2, I find you violated condition absconder based on a warrant being issued by the BOPP and evidence provided in support of that charge exhibits E and F. And on charge 3, I find you violated condition halfway house placement based on the evidence provided in support of that charge exhibits G and J. That includes the fact-finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. This purpose part of the hearing is to help determine what outcome I will recommend. So, P.O. McNeil, would you like to say anything else at this time?
What do you guys think?
That's it.
Do you guys should he be paroled, or should
So
they keep him in?
Yes, on behalf of Mr. Rodriguez, my client he's 41 years old. He does have one son who's age 15. Upon his release, he was at the Community Solutions halfway house in Hartford. He reported to us it was an open hearth. He was attending Hartford Adult Education. He's trying to get his GED. As already indicated by Mr. Rodriguez, he did have a full-time job at Restaurant Depot here in Waterbury, worked approximately 40 to 43 hours per week. He indicated to us, it looks like in April of 2024, did participate in emotional regulation outpatient group therapy, anger management, and case management services at Wilmore in Waterbury. And he was participating in the Explore program. He did approximately 8 out of the 26 classes prior to being remanded, and also reported to us he participated in the Connection, the treatment problem, sexual behavior. As far as
what?
Statement, he'd like to be placed in the halfway house at the Open Hearth in Hartford. He's apparently been there in the past. He did well there. As a backup, the Fellowship House Ministries in Groton. He is, since he's been incarcerated, he is on the wait list for his GED classes in domestic violence, and he is currently on medication compliant. Thank you.
Thank you.
Did they say S offense? I'm not sure if I heard right.
All right, so I'm gonna be right with you with the recommendation.
Oh, not yet. Okay. I'm not sure if I heard that. Oh, okay. Hey, thank you. Cool. Thank you. That's what I heard. I wasn't sure. So I did find the dude that had a messed up charge on here with the same name. So let me see. I think I found. Oh no. Well, this guy was sentenced to 30 years back in 2018. So that was what 6 years ago.
I listened to testimony today. I have from the state as well as counsel. I have reviewed all the evidence submitted by the state. As previously stated, there was an absconder warrant issued. You were in the community for about 2 months in absconder status. You were only in the community for about a month and 22 days before you absconded from supervision from the halfway house. And this is your 4th time absconding on this period of special parole supervision. I see 3 prior absconding violations, well, 2, as was stated, technical violations in the past. It is recommended a max time incarceration by your officer. I do see you are on supervision till February of 2028.
Yes.
And you do know if you keep absconding, you're never completing supervision.
I mean, I'm this time I'm not running. I'm gonna do my best this time.
How many times
I'm
have you said
tired
that?
of running. I'm tired of running. It seems like I'm not complying, but I'm gonna try this time my best to not run. I don't care if I have to do a year GPS. I turn myself in for a reason, and I'm taking my medication, so it caught me a lot calmer and much better. Thank you.
I hear you. I'm just saying what I see is you're having, I mean, you don't even give it enough time to even use any resources or do well because you've absconded before you can ever, participate. So this is actually, you have, I see 5 prior violations with 4 absconding. this would be your fourth right now. So it is concerning that you just see him to have a complete disregard for special parole supervision in the community. And based on that, I'm going to recommend that parole be revoked, be re-paroled for October 3rd of 2025. It's about a year and 2-month period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, mental health treatment and medication compliance, behavior management program for domestic violence and anger management, no contact with your victim SN, no contact with minors, and problem sexual behavior treatment. I'm going to present this to the board on 10/17. So the board can agree with that. They can lessen it or they can make it longer. They can revoke all special parole now as well. So it's up to the board if they would like you to be re-released ever back into the community. I am trying to give you one more chance to be under supervision, but we'll see what the board has to say on that date. You will get it in writing from the parole board what their final decision is about a week after 10/17. You understand?
Yeah, so when is it? You said October 2025?
Yeah, October, what did I say, 3rd of 25 is a recommendation, but.
It has to go to the board first on 10/17, Louis, then you and I will get something in writing about a week later with the final outcome, okay?
All right.
All right, good luck.
Thank you, sir. You're all set.
All right, and for anybody that's watching on TT, just want to give you guys a heads up that I'm in about 15 to 20 minutes, I'm going to be cutting the stream, so you might want to jump over here to this platform here and type this in right here, at collect call from. I do have the stream going on over there on that side. Also, I'm going to leave that one running because I gotta step off for a bit. So, but if you want to check it out, right here is where you want to go. You see this red platform with the white triangle, and just type that in right there. I got 4 streams. This would be the stream for Connecticut Board of Parole, and actually I'm gonna restart it up right now.
How you doing, man?
Good, thanks. We're here today for your rev hearing, so we are going to get started with that, okay?
Yes, ma'am.
Good morning, I'm Meisinger, hearing examiner for the Board of Pardons and Paroles revocation hearing concerning David White, number 337466. Today is October 8th, 2024. This hearing is being conducted via video at the BOPP Central Office in Carl Robinson Correctional Center. This is a public hearing. Public access to this hearing is available via video live stream.
Yeah.
Please state your full name and DOC inmate number for the record.
David White, inmate number 337466.
New counsel here today. Please identify yourself.
Your attorney Alfonzo, Sirica, public defender with the Parole Revocation Unit on behalf of Mr. White.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better reader evidence must establish that, more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole and release you and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. I recommend revocation. I'll make a recommendation as to appropriate sanction, and my recommendation be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge that the state, your parole officer, is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present relevant testimony. After considering all the evidence presented, I will announce my findings. If I find you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No, ma'am.
You have important rights today. You have the right to have an attorney present. You have counsel here. You have right to receive the written notice of charges of violation. Did you receive the written notice?
Yes, ma'am.
David White, okay.
You have a right to view the evidence against you before the hearing. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes, ma'am.
All right, so now review the charge the state your appeal is bringing against you and the information underlying each charge. Charge 1 under release direction absconder. You're charging officer forwarded on 4/10/24 approximately 11:26 p.m. You left the Walter Brooks halfway house without authorization from your parole officer or halfway house staff. You stated you were out and exited at the front door of the program. Walter Brooks halfway house is your only parole-approved residence, and you have failed to return or contact your parole officer, therefore demonstrating you are intentionally evading community supervision. Charge 2, Obey laws, drugs. Charging officer reported on around 2/20/24, use morphine. On around 3/4/24, use fentanyl. On around 3/12/24, use morphine. On around 4/9/24, use opiates. On charge 3 under additional condition, halfway house placement, your charging officer reported on 2/14/24, you were caught smoking a cigarette in your room, which violates your signed halfway house agreement. That's part 1, separated into 5 parts. Part 2 states 3/11/24, you were unaccounted in the community for approximately 8 hours and 29 minutes, which violates your signed halfway house agreement. Part 3 states 3/20/24, you're unaccountable in the community for 2 hours and 15 minutes, which violates your signed halfway house agreement. Part 4 states 4/8/24, you were caught smoking a cigarette in your room, which violates your signed halfway house agreement. Part 5 states on 4/10/24, you left the confined to the halfway house without permission from staff or your parole officer. This is a violation of your signed halfway house agreement. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A is notice of parole violation, also included is a parole violation report. B, notice of parole rights. C, conditions of parole. D, remand in custody. E, halfway house agreement form. F, offender misconduct dated 2/19/24. G, offender misconduct dated 3/5/24. H, Walter Brooks House misconduct report dated 3/1/24. I, Redwood Toxicology Lab results. J, offender misconduct 3/4/24. K, Walter Brooks House misconduct report dated 3/20/24. L, Redwood Toxicology Lab results. M, offender misconduct dated 3/18/24. N, Walter Brooks House incident report dated 3/12/24. O, Walter Brooks House misconduct report 3/12/24. P, offender misconduct dated 3/12/24. Q, Walter Brooks House misconduct report dated 3/20/24. R, Redwood Toxicology Lab results. S, offender misconduct 3/20/24. T, Walter Brooks House misconduct report 3/20/24. U, offender misconduct dated 4/9/24 times 2. V, Walter Brooks House misconduct report dated 4/9/24. W, voluntary admission form dated 4/9/24. X, incident report dated 4/10/24. Y, discharge plan report dated 4/11/24. Z, revocation hearing summary dated 10/27/23. Double A, revocation hearing summary dated 12/21/22. And double B, revocation hearing summary dated 10/20/21. Did you receive notice of parole violation report, and those other items I marked? Did you review them?
Yes, ma'am.
Okay, and counsel has filed the following exhibit. Pre-marked for identification is Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No.
We don't have any witnesses today. So it is now defense's opportunity. If you'd like to speak at this time.
Yes, I have Mr. White sworn.
Yes. Mr. White, I'm going to swear you in under oath so that you can speak today. Can you please raise your right hand?
Yes, ma'am.
You solemnly swear or sincerely affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth to help you God upon penalty of perjury?
Yes, ma'am.
All right, go ahead.
Mr. White, did charge number 1 under the absconder that you left on April 10th of 2024, you had some misconducts prior to that date at the halfway house, correct?
Yes.
And you were concerned about being locked up again, correct?
Yes.
Okay. And there was some dirty urines you were using around that time you left the halfway house. Is that fair to say that?
Yes.
Okay. And I know you've had some time to reflect, but leaving on April 10th of 2024 was probably not the smartest thing for you to do, correct?
No, it wasn't. Childish mistakes.
Okay. The under charge number 2 under the drugs is admitted during that time frame you were using, correct?
Yes.
Okay. The issue with smoking a cigarette on February 14, 2024, were you the only one that was in your room that day?
No.
How many other people were in the room?
The room was full, but the people were scared to take the charge, and I figured they were going to send us all back if nobody spoke up, so I just spoke up.
And you told them that you were the one that's actually smoking, correct?
Yes.
You actually smoking a cigarette that day in your room?
No, we just came in from smoke break outside.
Okay. On March 11th of 2024, do you believe it's part 2 or part B, whatever it's numbered or lettered, by you not being in the community, unaccountable in the community for 8 hours and 29 minutes. Were you in fact in the hospital on that date?
Yes, I was. And when you leave the hospital, they give you discharge papers. And I brought them to the program, well, the halfway house, and I gave it to them and they made copies.
Okay. So your testimony today is that you actually did have a stay, I believe it was Yale New Haven Hospital, if I remember correctly.
Yes.
And you provided the staff members at the halfway house with your hospital discharge papers, correct?
Yes.
And which date are you saying that is?
What date were you in the hospital? Do you recall?
I'm not sure, but in my own property that I have home, I have the paperwork just as well as they should have the paperwork because they made a copy and gave me the original papers back. Not only that, the hospital has documents of release.
Okay, but you did hand in actual discharge papers to the staff members? Okay.
Yes.
The part, I believe it's 3 or C, on March 20th of 24, so you're unaccountable in the community for 2 hours and 15 minutes. Do you recall where you were on that date?
Yes, I was at the App Foundation program. I did not have a cell phone where the halfway house sent me for my drug addiction, my issues. And I went to go get treated. And because I guess the time went over and I had a pass from the halfway house, they told me that I should have had the people there call, or I should have called. But the person who were giving me the interview for the intake of the program gave me a paper with his signature that I gave back to the halfway house that was signed too, that they have.
Okay, so for the incident on March 20 to 24, your testimony is you brought documentation signed by the App Foundation staff member to the halfway house, correct?
Yes.
The last one is April 10th is the same day. I don't have any other comments regarding the first part of the hearing. I just wanted to give you a little bit of background regarding some of the whereabouts of the infractions that he was given.
Thank you. And I do want to put on the record, the PCS addendum does read on 5/7/24, an absconder warrant was issued by the board for Mr. White. So what I'm going to do next is I'm going to announce my findings. So on charge 1, I do find you violated condition, the release direction absconder based on a warrant being issued by the BOPP and evidence that was provided in support of that charge, exhibits A and X, as well as testimony that was provided. On charge 2, I do find you violated conditional bail laws drugs based on the evidence that was provided in support of the charge, exhibits G, H, J, K, L, P, Q, R, U, V, and W, as well as testimony that was provided. And on charge 3, I do find you violated condition, additional condition, halfway house placement. This is based on the evidence provided in support of the charge, which is exhibits E and F on part 1, E, M, and O part 3, E, S, T part 4, E, U, that's part 4, and E, X, Y on 5. So I do, that concludes the fact-finding portion of the hearing. Before I make recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you'd like to.
Yes, on behalf of Mr. White, my client is 36 years old. He does have 3 children. On his previous release, he was at the Project More Halfway House program in Haven. He's indicated to us, looks like in November of 2019 to May of 2020, did successfully complete Project More Halfway House program in New Haven. And he was sponsored by his sister in New Haven, and he was there until he was remanded. He did participate in the Connection Halfway House program. While in the program, he was assigned to case manager, Ms. Chavit, and he's also the App Foundation Inpatient Substance Abuse Treatment in New Haven. As far as his schooling, he did sign up at New Haven Adult Education Center to obtain his GED. He signed up 2 weeks before he was remanded and has not been able to restart that program. It's also indicated to us he did sign up for the New England Tractor Trailer School in Bridgeport, and he's waiting to hear back on that. He was searching for work while he was out. He did, it looks like beginning February 23, 24, did participate in IOP and received medication-assisted methadone in New Haven, and he did have a counselor while he was there, and he's done numerous IOPs, including the one in Whaley Ave in New Haven. He did participate in the Explore Domestic program. He did 16 out of the 26 classes, and then they switched him over to the substance abuse treatment. So he has engaged in numerous treatments while he was out. Since he's been incarcerated, he didn't get a job as a chairman in the facility. He'd like to be placed in a halfway house either in New Haven or in the Waterbury area. He does want to attend high school to obtain his GED, and he does want to follow up with the tractor trade school in Bridgeport to obtain his CDLA license. And he's open to all employment opportunities. Thank you.
Thank you. So I'm gonna be right with you with my recommendation.
Yes, ma'am.
So I've listened to testimony today. I have reviewed all of the evidence that was submitted by the state. I do know this is your fourth violation on this term of special parole supervision, with your last sanction being 8 months for that violation. You were only out in the community 2 months before you absconded from the halfway house. You were serving a 6-month period of special parole for sale of hallucinogen, as well as 2 violation of protective orders and threatening second. There are 7 misconducts that you received while in the community for that short period of time. So based on that information, I'm going to recommend that parole be revoked, they be re-paroled for July 1st of 2025, which is about 11-month period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, behavior management program for domestic violence, no contact with your victim, JD. My findings will go on the parole board on 10/17. The parole board is going to make the decision on what's going to happen. They can use the date of 7/1/25 that I'm recommending. They can also shorten that sanction or lessen that sanction. Or they can make that sanction longer. They do have the ability to revoke special parole. You are on parole until 2026. So I'm trying to give you a few amount of time left in the community to complete that supervision. So it should be over a year left, a few months left if they go with my recommendation. Do you understand?
Yes, ma'am.
Okay, so you'll get the written decision about a week after 10/17 with the board's decision. And then it will list your conditions as well. Okay?
Yes, ma'am.
David, you and I will get something in writing a week after October 17th with the final outcome, okay?
All right.
All right.
Good luck, sir.
Yeah, thank you.
All right. So for anybody that's on the TT side, if you want to see you want to find my other channel right here, the other platform, if you look right here in the green with the little arrow, you just type that in to this streaming platform right here. If you see that red icon with the white triangle, if you go there, you type that in, you'll be able to find the account. I'm gonna be cutting the TT stream in about the next few minutes. So if you want to jump on over, we got about 30 people watching over here on the other platform. That one I'm gonna leave it running.
Good morning, sir.
Good morning.
I'm gonna be right with. Good afternoon. So we are here for your prelim today. So
Okay.
we're gonna get started with that in a minute.
This should be Anthony, I believe. Is it either going to be Anthony or Dwayne? So we got two more hearings on this Connecticut one that are going to appear, and then it looks like there might be one individual that's not going to be appearing for today. And then we also have two other streams going on. We also have Utah, and we have Pennsylvania. Is it Pennsylvania? Pennsylvania, yeah, I believe so. After this one's done, I would recommend the Utah one. That one they actually have individuals coming up in front of the parole board, and that one normally runs until like normally later on. It looks like they have quite a long list of individuals that are going to be attending today. So 11-month sanction, yup. Hey, and let me see what we got over here. We got 19 viewers on the TT side. And what do you guys think? What do you guys think this guy's name is? Is it Anthony or Dwayne? You guys tell me.
Your call has been forwarded to voicemail. The person you're trying to reach is.
It looks like they're trying to get a hold of somebody. All right, and for those of you that don't want to jump over, I'll be back on tomorrow. Tomorrow I'll have a little bit more time on my hands to
Your call
dedicate.
has been forwarded to voicemail. The person you're trying.
Okay, I'm trying to contact your officer. I'm gonna give them one more second.
All right.
And then we'll begin, okay?
Okay.
Hi, POBQ. This is P.O. Meisinger.
Hi, how are you?
Good. I have Mr. Anthony's here. We're going to start his preliminary hearing.
Okay, I just got your email. I'm so sorry, my phone didn't even ring.
Oh, that's okay. We're all good. We're going to start.
Okay.
Good morning. I am P.O. Meisinger, a hearing examiner for the Board of Parties and Parole. It's a preliminary hearing concerning Johnny's Anthony, number 375131. Today's October 8th, 2024. This hearing is being conducted via video at the BOPP Central Office in Harvard Correctional Center. Excuse me. This is now at Carl. You are now at Carl Robinson. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state to me your full name and DOC inmate number for the record?
Anthony Nathaniel Johnny's 375131.
Thank you. And we have a parole officer present. Please identify yourself.
Hi, good afternoon, Parole Officer Hughes for Parole.
This is a preliminary hearing, which is the purpose under Connecticut law. It's to determine if there's probable cause to believe you commit an act that violated the conditions of your parole, determine the act sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, I'll reinstate your parole, and releasing you, place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. So this is the procedure. I'm going to read you your rights. Then we will review the parole violation charge the state your appeal is bringing against you. I will review and identify exhibit file for the record. The state will then have an opportunity to adjust the issue of probable cause to the spirit of the allegations. After the state is finished, you will have the same opportunity. At the conclusion of the hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure?
No.
Okay. Your important rights today, the right to have an attorney. Do you want to continue without counsel?
Say I couldn't hear you.
Do you want to continue without an attorney?
Yes.
Okay. You've already received the written notice of charges of violation. Did you receive the written notice?
Yes, I have.
You have a right to review the evidence against you. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so now review the charge the state appeal is bringing against you and the information underlying each charge. Appeal McHugh, are you in the field? Can you read the charge or you need me to read it? Can you hear me?
I can.
You're faded.
Sorry, I'm able to read it if anyone's ready.
Okay, go ahead.
All right, the first charge is under release direction, which is for curfew on September 21st, 2024 at approximately 12:09 a.m. You were arrested by Enfield PD on an active arrest warrant for Connecticut General Statute 53A-182 for disorderly conduct. You did not have permission to be outside of your parole-approved residence at this time. And the second charge is number 2 for obey all laws. On August 23rd, 2024, you were involved in a physical altercation as reported by Enfield Police Department. Officers responded to the report of a physical fight at 60 Broadleaf Lane, Enfield, Connecticut, which is your parole-approved address. It was reported you punched a male victim in their face and you spat in the face of a female victim. After police investigation due to your actions, an arrest warrant was issued for you out of Enfield PD for Connecticut General Statute 53A-182 disorderly conduct. You were arrested on September 21st, 2024 on the aforementioned warrant and given a court date of September 23rd, 2024 on docket H14H-CR24-0766439-F. And I do want to point out that I think it was just this morning an addendum was approved for this case as Mr. Denise was heard at court.
Okay. What was the addendum?
All right, so I'll read you the full statement, which was submitted yesterday. Anthony Denise, inmate number 37513, was remanded to custody on September 23rd, 2024, due to an arrest on September 21st, 2024. He was charged with Connecticut General Statute, disorderly conduct on 9/21 by Enfield PD and released on bond for $5,000 that same night. He was given a court date of 9/23/2024, and then on October 2nd, 2024, he pled guilty at Hartford GA 14 on that disorderly conduct charge and received the sentence of an unconditional discharge.
Thank you.
Welcome.
So, let's see, and the state has filed the following exhibits that are pre-marked for identification purposes. Exhibit A, conditions of parole. B, notice of parole violation. C, parole violation report. D, remand actual custody. E, Enfield PD case instant report. F, state of Connecticut judicial branch spending case detail. G, BOPP decision information summary. And H is misconducts. Did you receive notice of parole violation report, and those other items I marked? And did you review them, sir?
The 2 charges, yes, I have reviewed them.
Okay. Do you need to continue this hearing to obtain any additional evidence?
The only thing that I was told was that the video evidence of proving that I didn't spit in her face and.
Well, do you want to wait? My question is: do you want to continue with this hearing, or do you want to continue it to another day to obtain information?
No, I can continue.
Okay. We have no witnesses. So what I'm going to do is I'm just going to swear you both in so you can both speak today. So please raise your right hand. You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give in this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes, I do.
Okay. So, PMQ, anything you want to say at this time?
I have nothing else to contribute.
No, I'm asking your PO first. All right, so nothing interesting. Well, this is the only time you can speak, so nothing to add today?
Nothing else to add.
Okay. So now it is your opportunity to respond to parole violation charges against you. However, remember that you may remain silent. So would you like to respond to the charges, sir?
Yes, I would like to.
Okay, go ahead.
So for the first charge as a curfew, I was working when I got pulled over. I sent my parole officer my time sheet for that week. I worked, I believe, 51 hours that week. I was actually in the process of working when I got pulled over. I was never told I was on. I ever had a curfew. I've been home 4.5 years. I've been working, taking care of my kids. I was blessed to buy a house this year, which I've been working on. For the curfew, I didn't know no one was told me I had a curfew, and I was working, so I didn't know I could get violated for a curfew if I was actually working for the curfew part. For the second charge, I was at my residency. They came to my house, assaulted me. The video, which is an evidence that was in court, which I don't know how it can be used here because the neighbor asked to be anonymous. So I don't know how that video would be able to be used. Because they asked to be not, how do you say the word? But they asked to be anonymous. I didn't harm anybody. I defended myself as I was on my property and got assaulted. I got my hair ripped out. I also got maced. I had a laceration to the left side of my ear. Let's see. That's about pretty much it.
Okay. Thank you for your statements. I'm going to be right with you with my findings.
Okay, thank you.
All right, so on charge 1, condition, release restriction, curfew, I'm making no finding of probable cause based on there being insufficient evidence to support this charge. There's no knowledge of a curfew that you were to abide by, or that you knew of a curfew that you were to abide by. And on charge 2, I do make a finding of probable cause, obey a law, obedience to the law. This is based on evidence that was presented, E and F, as well as was noted today, the conviction of the breach of peace and received an unconditional discharge. I do find the acts are serious enough to warrant revocation. So what I'm going to do, these charges are disposed. I'm going to schedule you to a rev hearing to come back relatively quickly because your charges are disposed of. So I'm going to schedule you for that. You will get notification of when that is, and then we'll determine. You do have a conviction already, but we'll determine what, if any, sanctions should be imposed or anything like that. So I will see you very soon, sir. Do you have any questions? Do you understand?
So pretty much what you're saying is you're going to put a new date that I'll see you guys soon. Okay.
Yes, because this is disposed, so I can bring you back. I'm going to get the addendum from PCS that's been submitted. Then I'm going to schedule your hearing very soon, and then determine what happens from there. Okay.
Okay.
So I will see you very soon. Go ahead.
Okay. So as in the video evidence, because my neighbor wants to be anonymous, how does that go into factors to show that I didn't spit in her face and I was the one attacked on my property? Like, how does that work?
Well, the thing is, you're in there. You already got convicted. So
Okay.
It's up to you how much you want to. You know, you got an unconditional discharge on it. I wouldn't. It's up to you what you want to do. You know.
Okay.
Okay.
Hold on, just for purposes of the situation too. So Janice, when you have your revocation hearing, we will kind of discuss your contact in regards to that situation, because I am asking for no contact with the people involved with the incident, and that's for your own protection, not just against you. Okay.
Yeah, we'll discuss all of those things.
I asked for a permanent what is that called? A permanent restraining order, because I've never had contact with my daughter's mother. I never went through her. She never knew where I lived before this incident.
So that's what we're going to address all that at the rev hearing. Okay.
Okay. Thank you.
Okay. So you're all set for today, sir. I will see you soon. Thank you, POMQ. Are you participating in the rev hearing then?
Yeah.
Okay. I will note that then. Okay.
Thank you very much.
Thank you. Have a good day. Have a good day,
Thank you. Have a
sir.
good day.
We'll see you soon. Yeah.
Okay, thank you.